Hello, hello. Welcome back or welcome, whichever. I would hope it's welcome back, but if it's just welcome, welcome to Rush to Judgment. I am Jessica, and this is a little, sit and chat. Sit and chat and watch. I am not by any means an expert in any subject matter that we are watching. I have no law degree, medical degree, no degrees in no things. I do have a criminal justice degree. That I do have that. That doesn't make me an expert at anything. I do have some children. So maybe that makes me an expert in momming. But other than that, I just like to talk a lot of shit. And I talk to myself a lot about a lot of different things. And I figured I might as well roll a camera while I'm watching some things that I'm interested in watching. And maybe, one day, somebody besides the voices in my head will be interested in the things that I say. So there's that. So here we are. We are on day 7. We're going to jump into it. I can't recap all of the things that have happened. There's been a lot, but a lot of nothing. We're really just kind of getting into the whole fact that it is state's really pushing home that murder in the second didn't really happen. That's how I'm seeing it. And I kind of like to look at it like, if I was a juror on this panel, that's how I would see it. And that's the way I look at a lot of trials because, that's what juries are made of, are, us regular dumb folk that don't usually know the ins and the outs of the law. So the only ins and outs of law that I know is from the lawyers on the YouTubes. So that's about it. That's about all I got. And Google. So yeah. So far, the state's been pretty good at convincing me that George has acted in pretty self-defense like. He was a Karen. He liked to call on suspicious folk in his neighborhood. Started up a neighborhood watch folk in his neighborhood. I guess he did it with good intention. He didn't want his neighborhood to get broken into. He didn't want people to, I think it was with good intention, I would think, and, wanted to help. But, those Karens. So, and then one night he just, honestly, with this last person here, this last detective, it kind of paints a broader picture. They're getting into the whole, interrogation of him, and he gets to tell more of his story and the consensus. I think the word is what it was. I don't know. I can't word right. Was that, he didn't actually really want to confront him. He's more of a follow at a distance creeper type. So he kind of wanted to see like which direction he was going. And then when he couldn't see him anymore, he thought he ran off and he lost him. So the way he described it was he was going to go, try to figure out his bearings of what he was closest to, so he could give an accurate location to the cops when they did arrive, if they arrived. But then on his way back to the vehicle, that is when he says Trayvon appeared and confronted him, and it all went on from there. So, again, situations like that, and then no eyewitnesses that saw anything. They just heard things and saw shadows, really. The only two people that know what the fuck happened, or what the hell happened, are Trayvon and George. We would like to think that everybody could be honest all the time, but that's just not reality. And quite frankly, I don't think I would want everybody to be honest all the time about everything. That would be a scary world to live in. So, I mean, honest about stuff like that, yeah. But just in general, like everyday life, if I say, hey, does this shirt make me look fat? And somebody says, fuck yeah, I'm going to be like, true, but you're a dick. Thank you. But anyway. So yeah. Okay. So that's my recap. They're getting ready to start arguing about some objection that they had about this witness about yesterday. I don't actually know. So if I get too bored, I will fast forward through it. Because again, I don't understand some things. And if they get to talking too much legal mumbo jumbo that I don't understand, I just fast forward.
Investigator
Sure.
did elicit from investigator Serena opinions as to the truth veracity of what the witness said, which is totally improper. Under the case law and under the motion we filed previously,
Doesn't
we would ask
matter.
the court to strike that and have the jury disregard that.
Okay, do you know specifically which questions and answers that you're objecting to?
I think it was towards the very end, and I can ask the court reporter.
If you'll take a moment to look at that, and then we can allow the court to know.
I'm just sort of in a recess. I'm going to queue up the audio because I want to use it across, so it's going to make some noise. Is that all right?
Yes,
What's yours?
to show me that I have to.
Oh, he said turn the audio off. Oh. Oh, that is so itchy. Get to it.
Person took that on, then he can now tell what he believes to be the result of that context.
I'll give you a moment to read Supreme Court of Florida case Tumlin, TUMBLIN versus State, found at 29 Southern 3rd, 1093. decided in 2010 under head notes 9, 10, and 11. I'll quote, allowing one witness to offer a personal view on the credibility of a fellow witness is an invasion of the province of the jury to determine a witness's credibility. It is clearly error for one witness to testify as to the credibility of another witness. Moreover, it is especially harmful for a police witness to give his opinion of a witness's credibility because of the great weight afforded an officer's testimony. Police officers, by virtue of their positions, rightfully bring with their testimony an air of authority and
Wait a minute, but you're not supposed to weigh one person's testimony more than the other. That's part of jury instructions. Is it not?
legitimacy. A jury is inclined to give great weight to their opinions. And then another case holding that police officers' comment that witness was credible and positive in her pretrial lineup identification was error requiring a new trial.
Yes, my concern, and I'll take a moment to read it, is that in that context, it was a question of affecting the client's right to a fair trial, because in effect what happened in the Tumblin case was the officer vouched for the credibility of an eyewitness who came in and said, I'm certain that that's the defendant. And then the cop came in and said, well, I'm certain that I believe her when she says, I think it's him. That's affecting my client's right to a fair trial. I think it's a much different perspective under the facts of this case. Now, again, I need to read this and also get some case law, but a quick response is it's a question of whether or not my client's right to a fair trial is being affected. I don't think the same would apply to the state when it's the state's own witness who presented a conflict or an attack argument to my client and he successfully responded. But I might have a moment to review it.
Mm-hmm.
While that's going on, I really wanted to address with the court.
Okay, well, we can do that.
No, you can wait till he's done reading and he can focus on what the hell you got to say.
Controversial is.
Okay, well, just one second. In the Jackson case, which is also Supreme Court of Florida, 107 Southern 3rd, 328, decided November 2012 under head notes 3 and 4. Generally, a witness's opinion as to the credibility, guilt, or innocence of the accused is inadmissible. Allowing one witness to offer personal view on the credibility of a fellow witness is an invasion of the province of the jury. Cites to the same cases, but in this case, it was the opinion as to the credibility, guilt, or innocence of the accused.
Correct, not given by a police officer, an adverse witness. That was another witness where it
Well,
was.
if you read further down, it cites to Pausch, P-A-U-S-C-H versus State, 596 Southern 2nd, 1216, that holding that admission of officer's statement expressing his disbelief of the defendant's story and accusing her of lying and committing the crime was reversible error.
Again, I don't think that's the facts that we have here.
Well, because they're opposite. He's testifying as to the truth and veracity of your client's statement.
Just need a moment.
Go right ahead.
Yeah. And the state saying, no, 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 no. I don't agree with my own witnesses' statements, and I object. Because I'm a bitch. And I want to be one. Just fucking recross him. Recross. Quit being such a bitch, Charlie Brown. Fuck. Ridiculous. Ridiculous. back and forward.
It's the same difference.
Well, again, I understand the court's concern and the state's objection, but within the context of an investigating officer charged with the responsibility to make exactly those determinations, whether or not he believes him, whether or not he's going to arrest him, whether or not he's going to charge him, whether or not he's going to believe one witness over the other, that is exactly what an investigating officer has to do in the context of his investigation.
And if the question would have been answered, no, I thought he was not telling the truth.
It would be out there.
Your Honor,
You could have asked it that way. Could have answered it that way.
our position is that these cases are right on point. The state is also entitled to a fair trial. And these cases are right on point as to this issue. Mr. O'Mara, on behalf of his client,
The
cannot
state.
claim that because the officer said, his belief at that point, that he was telling the truth, that should be admissible. As the court noted, if the defendant has said he's a liar, in fact, I believe he's guilty because ABC and all that stuff, that's improper. And we had filed a motion in limine that the court heard back in May, the court ruled on it and granted. And I think the
Well,
rules
it's
should
already
apply,
out
the law
there,
should
so
apply
what
to
you
the
gonna
state
do?
and to the defense.
Okay, do you have a suggested curative instruction?
I would ask the court, read that, have the court read it or read it back, whichever way, and then ask the jury to disregard that and that is improper comment by a witness as to the truth or veracity of another witness, in this case, the defendant.
Anything else?
No, Your Honor.
Is Detective Serino here? Oh, you had another matter you wanted to take up?
It pertains to a potential witness for later in the day, that being a Professor Gordon Pleasance. Your Honor may recall the state last week or a little before had filed a motion to perpetuate his testimony due to his being unavailable. That was heard, objected to, and granted. We scheduled the deposition to perpetuate for the last night that he would be in town, which was, I think the motion was granted on a Monday morning, and he was set to depart Wednesday morning, so we set the deposition and noticed it for Tuesday night. Everybody showed up except the defense, and I communicated with counsel for defendant on that night, and basically I think it was just a matter of people forgot about it in all the rest of things that was going on, and I understood that. But my problem was, and I explained this to them, that the witness wasn't available to reschedule because he was having to be at the airport in the morning and fly out and was going to be essentially unavailable. So I proceeded to at least preserve the direct testimony on videotape and a transcript, both of which have been provided to counsel. The witness indicated that there would be sporadic availability, perhaps for video conference type testimony. He is traveling through the New Mexico desert, I believe, on kind of a hike, and is occasionally reachable by cell phone, or if we leave a message when he gets to a next destination, sometimes he can find enough service to call. Yesterday, I managed to reach him via that method, and Mr. West informed me last night that they were not going to be stipulating or agreeing that the perpetuated testimony could or should be admitted, and therefore they wanted the witness, if he was going to testify, to have to do so, I guess, by video link or some other such. He is not available to do that today for sure, because he is in transit, he said, across a couple different states, and given the environment. He may, once he arrives tonight, be able to locate a place to be available tomorrow morning, even though he's a couple time zones away. But he can't guarantee me that. He just believes that would be likely. So I wanted to, number one, bring that to the court's attention. Number two, hear how the defense would propose that we handle that situation or issue if there's an objection to what's potentially playing that videotape, and get that out of the way now before we run into it this afternoon when we want to call a witness.
Response?
Oh, this is the one you want to
I'm not quite sure what the proposal is. I think it's to play the video of Mr. Pleasant's direct testimony and then not afford the defense an opportunity for cross-examination. I don't know if that's it. That, of course, is completely unacceptable. If Mr. Manti seeks to offer the witness's testimony through Skype, then he should offer the direct, and then we can cross as appropriate. We also need an opportunity, though, to speak with Mr. Pleasance prior to him taking the stand by whatever method that he does. The motion to perpetuate, as the court's aware, was a last-minute motion during the course of the trial when the state realized Mr. Pleasance wasn't available. We don't fault them for the effort that they made. We didn't become aware of the significance, frankly, if any, of this witness's testimony until as well sometime after the trial started, when we began to realize why he was being offered in connection with Mr. Zimmerman's coursework. I think Mr. Pleasance may have taught an online course at the Seminole State College. In any event, the issue last Tuesday was a scheduling complication. I don't dispute that the deposition was set sometime after court on Tuesday, and that at some point may have known that. There were no reminders or any conversation during the day, and then at the end of the day, when Mr. Manti had set up the video deposition with Mr. Pleasance here and contacted me by phone to say, where are you? At that point, we had already left the courthouse, but more importantly, Mr. Zimmerman had already been escorted off the property. A motion to perpetuate testimony either requires the accused's presence or a specific waiver. And we were unable to accomplish either of those at that moment. I apologize to Mr. Manti, and here we are today. As the court's aware, we've been working full days and then some. And of course, there's lots of work to do at night and on the weekends. With this witness's unavailability, I think we should target when he is available, give us a chance to talk with him, and schedule his testimony by Skype if he's otherwise allowed to testify. We have no objection to that. We have no objection that the court place him under oath as opposed to him being in the presence of a notary, wherever it is where he testifies. And we have no objection if at some point when he testifies, it's out of order.
Okay, response?
I guess my response to that is twofold. If we're discussing waiver, the state's position is, we had the argument on Monday. The court was pretty clear in its ruling. I think we were all pretty clear on the reason that we had to do it was because the witness was leaving before we would actually have the opportunity to start trial and present his testimony. And that's the reason it was set when it was. So from the state's position, number one, for whatever reason the defendant and his counsel didn't show up, we think that should constitute a waiver of the right to presence. Simply not coming isn't really a reason for the direct testimony. My counter proposal is that we play the direct, and there was one exhibit that he identifies during the direct and that I intended to introduce. Play the testimony of the direct, introduce it, and if counsel wishes to cross, then hopefully he would be available tomorrow, but I can't, obviously I said, I can't guarantee that given the locations and places, and that's the reason we moved to perpetuate in the first place. And if they want to cross at that time, that's fine. I'm not attempting to deprive them of the opportunity to completely to cross.
Well, there's a lot of different scenarios that could play out here. And if you could find out sometime today what his availability would be tomorrow, let me table this argument till this afternoon.
Yes, Your Honor. Thank you.
Okay, thank you. Is there anything else? Let's get Officer Serino in here, please. And Shelley, can you queue up to that last question and answer? Are we ready to bring the jury in?
Yes, Your Honor. Thank you.
Let's bring them in. That one question and answer, yes. I think it was like taking the hypothetical out of it.
I don't understand. I don't understand. Most likely.
Please be seated. Shelley,
Oh my God, stop doing that. In or out, in or out.
just one.
No.
Okay. Good morning, ladies and gentlemen, and welcome back. During the overnight recess, did any of you have any discussions with each other or with anybody else about the case? No.
Nobody cares.
In the context of that interview. I want to back up a little bit. I mentioned yesterday.
I'm going to have the court reporter read back a question and answer from yesterday afternoon and give you an instruction on that.
So she's going to read back the question and the answer and then tell the again. So in case, it went the first time, they're going to read it back and the answer again. And then she's going to tell them to ignore it and say, just regard that. That's not evidence. What the fuck? State, sit the fuck down. It was dumb. It's dumb as fuck.
That Shelley, you may do so.
Sit down. Bring more attention to this shit. It can't go away. Once you say the shit,
Question was, so
fucking out
if we
there.
were to take pathological liar off the table as a possibility, just for the purpose of this next question, you think he was telling the truth? Answer, yes.
Okay, ladies and gentlemen, my instruction to you is that that is an improper comment by a witness as to the truth and veracity of another witness, and you are to disregard the question and the answer. Thank you very much.
Okay.
Mr. O'Mara, you may proceed.
Morning, officer. How are you?
Good morning, sir. Fine, thank you.
When we were talking yesterday before break, we were talking
You're
about
also not
the,
supposed to weigh one person's testimony.
we agreed to use the
more
term
than
challenge
another's.
interview, correct?
Yes, sir.
And we were talking about the context of that challenge interview, right?
Yes, sir.
Some of what you challenged him with
The fuck out of
in the context of that interview. I want to back up a little bit. I mentioned yesterday as an example that one technique that law
Charlie Brown
enforcement
kids.
officers are trained to use is what I call a command voice. And of course, you're familiar with that, right?
Yes, sir.
That's when you basically have to take control of a situation and you say it in a stern voice, almost a yelling voice, because what you want to do is let everyone know you're the person in charge, correct?
Yes, sir.
In that context, you're not actually yelling at the person like you're angry with them, are you?
No.
It's a technique to gain control of the situation.
Right.
Correct.
Yes, sir.
Similar in the challenge interview, it's not as though in this context you're actually angry with Mr. Zimmerman, correct?
No, anger's not a part of it. No.
Right. It's just a technique or a tactic that you use to try and undermine his confidence in his own story so that you can see if he breaks.
Charlie Brown over
correct?
there.
Yes, sir.
And that's the purpose of it, correct?
Yes.
Such a
Okay.
dumbass.
So that when you challenge him, in an example, you said to him, you sound kind of frustrated on the phone conversation. Because everyone's going to hear these things, you know. What was your purpose in that?
On which phone conversation? On which phone conversation?
I presume, having read the entirety of your interview, that you're talking about how he sounded on the non-emergency call.
Okay.
And was that in an attempt to sort of, again, undermine his confidence in himself so that you might get some movement in his story?
Not necessarily. I mean, it could have been. I'm
Okay.
not quite sure my comment might have been or what tone I might have used.
Okay. Would you then defer for the jury's consideration to the way you present to yourself in the challenge interview rather than just me going over or repeating it in sort of bare words?
Yes, sir. Yeah.
But you agree that your purpose was to challenge Mr. Zimmerman
It could have been, yes, sir.
and to try and undermine his confidence in himself such that he might tell you more or change his story in some way, which would then give you an opening, correct?
I would classify it more trying to extract truth if he's hiding it. Yes, sir.
And did you extract any truth or anything, any change in his story through this technique?
No, sir, I did not.
He was in fact consistent throughout, correct?
Yes, he was.
And he was also consistent with both all of his prior statements, correct?
To my knowledge, yes.
Okay. As the chief investigating officer, you had availability of those prior statements, correct?
Yes.
And there were some changes. I think you said yesterday there were certainly some expansions and even some minor inconsistencies, right?
Yeah, there was some variations of accounts.
But nothing that you considered significant.
Nothing major, no.
Nothing that evidenced to you that he was lying to you?
Objection, Your Honor. It's improper argument.
Sustained.
Any inconsistencies that you consider to be significant?
None which I can challenge him with, so I would say no.
With some help, hopefully this will work, I'm going to play with you a portion of the tape that you heard
Play with
yesterday. I understand that I'm going to play it. If you can't hear it, I'll play it a second time. I believe this is a part to focus you on the investigation where you are playing for Mr. Zimmerman the 911 call, which has the screams in the background, to put it in context. And I'm going to try and get the volume correct, Your Honor, so I may need a couple of tries. Oh, I'm sorry. It is 182. It is the...
Okay, and is it a male or female? It's a male. And you don't know why? I don't know why I'm yelling out, but I don't.
Did you hear Mr. Zimmerman?
I'd have to hear it again.
Sure. I'm going to keep it low, Your Honor, until we get back to that point.
But now we're here working for you here, okay? No, that's what got up in your mind, okay? And if there's anything that needs to be changed.
Your Honor, I'd ask that if you play at
I'm
the
sorry.
same level so that the jury can establish a
I
context.
think he's just trying to.
I'll do that, Your
I
Honor.
can't do this anymore, okay? For this one.
911, you need police, fire, medical.
Hear that voice in the background?
Yeah.
I'm not sure there's just on screen. 911, you need police, fire, medical. I'm not sure there's
That's you.
on screen now.
In the transcript, and I think it was pointed out on 2 occasions by Mr. Dillorionda yesterday that there was a suggestion that Mrs. Zimmerman said, doesn't even sound like me. You remember that?
Yes, sir.
Now, is it your opinion? Well, your opinion.
Oh, don't do that.
Did you interpret that Mrs. Zimmerman was denying that it was him, or just that it simply didn't sound like him?
Your Honor, I'm going to object as to having this witness testify about what the defendant was thinking based on what he said.
Okay, sustained.
Did that change the direction of your interrogation of him, that statement that he said, doesn't even sound like me. Did that change the direction of your interrogation of him at all?
No, it did not.
Did that cause you any concern whatsoever?
No, it did not.
If I might just have a moment, Your Honor. I want to make sure that I get the right portion of the tape. And I think I might need to just play it a moment more. So I'm going to do that now, and it may be on that portion.
And what's the address of the name? 1211 Twin Trees Lane? Twin Trees Lane? Is this in the Twin Lake town, New Hampshire? Yes. Okay. And is it a male or female? It's a male. And you don't know why? I don't know why I'm yelling help, but I don't know. Then someone's like, please stop. Okay. Does he look hurt?
Did you hear it then, in the background?
What he said?
Yeah.
Uh,
Nonetheless, you heard it that night, correct?
yes,
And you heard his words being, does it even sound like me?
yes.
That didn't change what you did as far as the investigation?
No, it did not.
Why is she doing this? Stop it. Oh.
Similarly, in the challenge interrogation, you even told him that you were moving from the interrogation room to another area out by your desk as well, correct?
Yes, sir.
That was both to listen to the tape, correct? But to also change the setting for him?
No, it's supposed to be because of the facility. I didn't have any of, I didn't have a computer inside the interrogation room.
Now, you said in response to a question from Mr. Delaionde yesterday that you perceived Mr. Zimmerman's injuries to be minor, correct?
Yes, sir.
And that was as you looked at him that night after midnight.
Definitely not like
Yes,
for
sir.
at name.
And we showed you the picture of his injuries before he was cleaned up, correct?
Yes, sir.
Did he need to have any injuries at all for you to
No,
look
you already
into the
said that.
investigation concerning both the crime and any possible defenses?
No, sir.
That's not an element, is it?
No. As far as him having injuries, no.
We already went through that. We already went through that. Already went through that.
And
What that is.
you saw him on the 27th after midnight, correct?
Yes, sir.
And then he went to work the next day and then saw you for the 27th in the afternoon for the recreation or the recreation video, correct?
Yes, sir.
And then he came back to talk with you again voluntarily on the 29th, correct?
That's correct.
And did you talk to him after that?
Yes, we had conversations.
And that was over the phone?
Yes, sir.
Did you talk to him again in person?
Not that I can recall.
When you spoke to him on the phone, that was in order to, again, sort of forward your investigation of both the crime and any defenses to it, correct?
I believe he contacted me, but yes, the ultimate goal would have been to forward the investigation.
And in all of his communications with you,
What did
even
I
after the
say?
29th, he was cooperative,
Yes, he was.
answered whatever questions you had for him,
Oh
Yes,
my
he did.
God. that's
presented himself
a
to do whatever it is that you wanted
whole
him
lot
to
of.
do.
Yes, he did.
Hold on. I can speed this up.
You have done even more than just take the interviews of my client as part of your investigation in this case, correct?
Yes.
Yes, sir. From other aspects of the investigation, yes.
Met with other witnesses.
Yes.
You met with Tracy Barton, correct?
Yes, I did.
At your office?
Still here.
Yes, there at his residence also, or at the residence in Twin Retreat.
Why did you meet with him at your office?
No, Jack, to be honest, go to direct and calls for hearsay too.
Well, actually,
Okay, let me take it one at a time. It was not covered in direct. It's not hearsay, the question and the answer that it would elicit. I have to sustain on wasn't covered in,
May I respond?
yes, you may.
I would just allow a little bit of leeway for this, the chief investigating officer in the case, to ask him what else he has done in doing exactly his duties.
Well, you could do that in your case.
So I will call him as my witness,
If you choose to do so.
then I will do that. Thank you, Your Honor. And we need to get this back to the clerk. If I can just have a minute, you can use it?
Not right now.
Redirected.
I actually do know how to use a laptop on occasion. Thank you very much.
Good morning, sir.
Good morning, sir.
I'm not going to ask you to the opinion of anybody or to guilt or innocence. I understand that's improper, and I can't ask you that.
Yes, sir.
My question is, let me object, Your Honor, as to that non-question of this witness. Nothing but a comment on your previous ruling, which is inappropriate.
Sustained.
My question is, Mr. O'Mara, on behalf of the defense counsel, asked you some questions about anger and disdain. Do you remember that, about ill will, hatred, all that stuff?
Yes,
Do you
sir.
remember him asking you a series of questions regarding that?
To somewhat, yes, sir.
Okay. Specifically asked you about your interview with the defendant, that you had reviewed it, and also Investigator Singleton's interview, and whether you found any evidence of hatred, spite, anger, disdain, ill will. You recall a series of questions regarding that?
Somewhat, yes.
Okay. Want to play something for you, sir? If I can figure out how to do this.
Just use this drop down.
Okay, that does come up there. Oh, okay. Our first play from you from the non-emergency call that defendant made.
Okay. These assholes, they always get away.
Is that something you would use in reference to somebody that you can invite over for dinner? Would you call them these assholes?
No, sir, I would not.
Does that seem like to you like a friendly comment about somebody else?
No, sir, it's not.
Okay, how do I do it again now?
Yeah, you go straight in, don't turn and make a left. Shit, he's running. He's running? Which way is he running? He's down towards the entrance of the needle. Okay, which entrance is that he's heading towards? The back entrance.
Did you hear that last comment the defendant stated, and pardon my language, these fucking punks?
Yes, sir.
Okay. Is the word, pardon my language again, fucking punks, something that you would refer to, something good about people when you reference them?
No, sir, it's not.
Are you saying, or you did testify when you were cross-examined, that those two, these assholes always get away, and pardon my language again, these fucking punks, that he said that because he wanted to interact and meet and invite Trayvon Martin for dinner that night?
Excuse me, Your Honor. That would be speculation.
Sustained.
Are you saying that those words were uttered by the defendant in reference to wanting to meet the victim?
Excuse me, Your Honor. That would be speculation.
I'll be glad to rephrase it.
Sustained.
Does that not indicate ill will, hatred, and spite against somebody else, sir?
No, it does not.
In your opinion, calling somebody, reference them as, pardon my language, fucking punks?
That is ill will and spite.
It is?
Yes.
Okay.
Are you following him? Yeah. Okay, we don't need to do that. All right, sir, what is your name?
Sir, you were asked by Mr. Romero on behalf of the defendant in terms of whether there was evidence that he had followed him or not. Do you recall being asked that?
Yes, sir.
And you recall you, in fact, to use Mr. Romero's words, challenged the defendant regarding that. Do you
Yes,
recall
sir.
that?
Yes.
About whether the defendant was following him or not? You
Yes,
recall
sir.
that? Did you hear the word there by the non-emergency operator about whether he was following him or not?
Yes.
And did the operator not tell the defendant not to do that?
In so many words, yes.
Okay. In your interviews and review of Investigator Singleton's interviews, sure. Sorry. In your interview and review of Singleton's interviews, Did the defendant in your interviews of him too, did he ever say he was excited? You want me to rephrase it? Well, I'll be glad to rephrase it. I apologize. In your interview and also your review of Investigator Singleton's interview of the defendant, which you've had an opportunity to do, correct?
Yes, sir.
Mr. Romero asked you about those. And did the defendant ever indicate that he was happy that there were burglaries being committed at Retreat at Twin Lakes?
No, he did not.
Did he ever say he was excited that his neighborhood was getting burglarized?
No, you're not.
In fact, didn't he say this, sir?
950.
This is the correct one? So you live at 1950 Retreat View Circle. Okay. I'm just gonna keep quiet and you tell me the story. You tell me what happened tonight, okay? Yeah, or whatever led up to this. Anything you want to tell me about what happened and why it ended up, what it ended up to where this boy got shot. Okay.
The neighborhood has had a lot of crimes. My wife saw our neighbors get broken into and she got scared.
Can you talk about the residents or vehicles?
The residents.
Okay.
While it was occupied. So I decided to start a neighborhood watch program in my neighborhood.
Okay, what's the name of the neighborhood?
Retreat at Twin Lakes.
Now, Investigator Singleton asked the defendant what led up to this in terms of the shooting, correct?
Yes.
And that's how you replied, correct?
Yes, it is.
Okay.
Neighborhood watch, okay.
Wendy Doorbell, Sergeant Hurts, Officer Buchanan, and I'm the coordinator. And there's been a few times where I've seen a suspicious person in the neighborhood. We call the police, the non-emergency line, and these guys always get away.
What made them suspicious?
You recall hearing that in terms of Investigator Singleton asking him, the defendant, about what was going on, and he's stating, as he stated there, that they always get away?
Yes,
All
sir.
that?
Yes.
So he said it again. He said it earlier
Didn't he
that
say that
night.
to the non-emergency operator also? But he used more colorful language, part of my language. He used these assholes always get away, correct?
Correct.
And those words were uttered within minutes of the actual shooting, weren't they?
Yes, they were.
So it was still fresh on his brain. That they always get away.
I've
He's
called
trying to
before,
help
the police have come out, but
them not
these
get
guys
away.
know the neighborhood very well, and they've cut in between buildings and.
You're saying these guys, who are these guys?
The people committing the burglaries.
So you've seen more than one person like looking suspicious and doing these burglaries?
Yes, ma'am.
Okay.
Now, Investigator Singleton had him clarify when the defendant in that interview on the 26th stated these guys, he had him clarify or describe what he meant, correct?
Yes, sir.
And defendant said the people committing these burglaries, correct?
Yes, sir.
And then to the non-emergency operator earlier that evening, when he spotted Trayvon Martin, he made reference to, using more colorful language, part of my language, these fucking punks, correct?
Correct, sir.
So when
they've
Mr.
been
Romero asked you about
punks.
profiling, isn't it accurate that he was profiling Trayvon Martin as a criminal? He assumed that he was a criminal that night?
The objection on that call for speculation.
Sustained as a speculation.
Do you recall Mr. Romero asking you about whether he was profiling?
He profiled him as a
defendant- I'm sorry,
suspicious
Trayvon Martin?
person.
Yes.
Okay. If somebody were to believe that another person is a criminal, could that be a form of profiling?
The objection on that would be either speculation or irrelevant.
Overruled.
If I were to believe that you're a criminal and I followed you and did something, wouldn't that be profiling you?
And I'll object based upon improper opinion testimony unless we're opening that door.
He can testify if he knows in his experience as a law enforcement officer.
As long as we're going to his opinions. Fine.
Let me make sure it's clear. If I were to believe that somebody was committing a crime, could that not be profiling that person,
Object,
believing?
Your Honor, lead.
Overruled is deleted.
You understand my question, sir?
Yes, I do. It could be construed as such, yes. Construed as such, yes.
Your review of the evidence there, was there any indication that Trayvon Benjamin Martin, the young man, I think 20 days past, that just turned 17, was committing a crime that evening, sir?
No, sir.
Was there any evidence that that young man was armed?
No, sir.
You have to be armed pose a
You were asked by
threat.
Mr. O'Mara several times, and I think he made reference to your last interview being a challenge interview, I think. I don't know if you completely agreed with him on that or just agreed to use his terminology for that. Did you agree that that was a challenging interview?
I wouldn't quite classify it as that. However, it could be viewed as a challenging interview based on his view of it.
Okay, his being Mr. O'Mara's?
Yes.
Okay. Let's assume for purposes, let's call it a challenge interview, but you know what I'm referencing to?
Exactly.
Your last interview with the defendant on February 29th.
Yes, sir.
Okay. And Mr. O'Mara asked
Dick
you
Charlie Brown.
whether there was inconsistencies or not.
Yes, sir.
Okay. And I want to play certain parts of you where I believe you at least questioned him about whether he had said something inaccurate before or said something different. Do you recall that?
Yes, sir.
And I want to ask you about these, if I could.
Yeah, we got him on the line. Just let me know if there's anything else. Okay. Always get away.
That's it. These assholes. It's behind that.
People that victimize me.
Can't you just tell him there that a week later?
Do you recall you playing that recording for the defendant and asking him about that? Now that somebody may refer that to a challenge, but do you recall questioning about that?
Yes, sir. I pointed it out to him.
Okay. And he made reference to, when he made reference to, pardon my language, these assholes as people who commit crimes, correct?
Yes, sir.
Follow him, and I wasn't following him. I was just pointing in the same direction.
That's following.
Right. I was on the other side.
Now, you were questioning him, pointing out an inconsistency, weren't you not, that the defendant was claiming he was not following him, and you're telling him, that's following him, correct? You recall saying that?
Yes, sir.
Bernie. Your name is Bernie.
So shooting's running, and I'm getting out of my car in an instant to make sure I don't lose sight of this guy. That's what it sounds like. Are you following him? Because that's what it sounds like you're doing. That's why he asked you the question.
I
It
prefer
sounded
Charlie
to the
Brown.
dispatcher like that you were running. And that's why he asked you that question. Are you following him? And your answer is yes. Okay? But then you get to the other side and you're concerned
John
about
God.
walking past this guy when you've already been chasing him, essentially. And he's telling you to go back to your car, and now you want him, or not him, you want us to believe that you're concerned about having a flashlight to move back where you just ran? You kind of protected him. You know what I'm saying?
Okay, that's all you're looking for.
Do you recall you and Investigator Singleton questioning him about that?
Yes, sir.
About there possibly being an inconsistency based on what he's saying and what the evidence showed?
Inconsistency as far as his acts and his words,
Yes, sir.
to clarify.
Right. And by the way, while we're at this point, Mr. O'Mara asked you about videotaping. You recall that you had questioned the defendant about videotaping, and you showed him the victim's camera that was at the scene near where his body was. You recall that?
Yes, sir.
And you stated, I believe, in direct and in cross-examination that you were bluffing him. You were telling him that the victim had potentially videotaped the whole thing?
At that point, yes, it was a
Is that
bluff.
correct?
Yes, sir.
And you knew that not to be true, correct?
At that point, yes.
Okay, all right. And my point is, and the defendant made a comment like, oh, I hope to God it was videotaped. You recall that?
Yes, sir.
Okay. Now, Mr. O'Mara asked you about stores and other places that have videotapes out there,
Yes.
correct? Now, the defendant, I believe you've already testified, was head of the neighborhood watch, correct?
Yes,
And
sir.
had lived in that neighborhood for a while, correct?
Yes, sir.
Okay, so he would have been aware whether there was videotaping or not in any of those buildings, correct?
I would assume so, yes.
Okay. And I know you weren't there when it happened, but you would agree that the interaction between the defendant and the victim in this case, the defendant was aware of whether the victim, before he got shot, took out the video and videotaped the defendant, correct? Would know that.
I would object, that would be speculation.
Sustained.
Was there any evidence that the victim, before he got shot, said, hold on, before you shoot me, let me take out my camera and take a picture of you as you're shooting me?
No, there was none.
Was there any evidence that the victim, as the defendant was following him, said, hold on, I'm going to take a photograph of you so there'll be a record before you shoot me that you're following me?
Object, Your Honor, that was asked and answered.
Overruled.
Was there any evidence that the victim, as the defendant was following him, said, hold on, stop right there, let me take a photograph of you or let me videotape you before you shoot me or before you're following me and then shoot me?
No, sir.
And so when Mr. O'Mara asked you about whether the defendant knew that or not, he would have known that, correct?
I would assume so, yes, sir.
So he basically knew you were bluffing, is what I'm getting at.
Objection,
Based
Your
on,
Honor. That would be speculation.
Sustained.
I'll be glad. Let me play another recording for you if I could, sir. The defendant was aware of whether the victim, before he got shot, took out the video and videotaped the defendant, correct?
Judge,
Would know that.
Judge, that would be speculation.
Sustained.
Was there any evidence that the victim, before he got shot, said, hold on, before you shoot me, let me take out my camera and take a picture of you as you're shooting me?
No, there was none.
Was there any evidence that the victim, as the defendant was following him, said, hold on, I'm going to take a photograph of you so there'll be a record before you shoot me that you're following me?
You can record.
Was there any
whole
evidence
time.
that the victim, as the defendant was following him, said, hold on, stop right there, let me take a photograph
You
of
can
you, or let me
record
videotape
without
you
having
before you shoot
anything
me,
in
or before
focus
you're
or
following
on
me and then shoot me?
camera.
No, sir.
Dipshit. You're stupid.
And so when Mr. Romero
Keep
asked you about
everything
whether
so
the defendant knew that or
fucking
not, he would have known that, correct?
I would assume so, yes, sir.
So he basically knew you were bluffing, is what I'm getting at.
Objection,
Based
Your
on-
Honor. That would be speculation.
Sustained.
I'll be glad. Let me play another recording for you if I could, sir.
That you're concerned about having a flashlight to move back where you just ran?
You're looking
Hey, what
for,
happened? You know what I'm saying?
okay, it sounds like you're looking for.
You brought a flashlight. You wanted to go see him.
You want to catch a bad guy?
It doesn't, that's.
Fuck them punks, you can't get away. Listen, we're outside that interrogation room, okay? We're in a whole different area right here, okay? This is where, you know,
You were questioning him about what he had said, about the evidence, correct?
Yes, sir.
Is that what you were doing there?
Yes, sir.
so we go,
He's a super lawyer.
at what point is that question happened? Prior to you shooting him, he was on you, correct? Okay, and you were able to reach the holster. He shot at point blank range, he was on top of you, right? And nobody that young, nobody came out to help you. And I can't pinpoint where you were smothered. That's the problem I have. And nobody's saying they saw smothered you. People are saying they saw someone on top of you, but they didn't see about the smothered part. So,
When we're listening to the streaming, it just sounds like it's a hesitation for streaming. It sounds like it's 15 minutes. It sounds like it's gonna stop. But we don't hear it stop.
we don't hear.
You recall you and Investigator Singleton challenged, to use Mr. O'Mara's words, challenging him about whether he was being smothered or not?
Yes, sir.
Okay. Can you please? You're on.
Super lawyer status. Don West is the Zimmerman's attorney. He has been awarded super lawyer status.
You recall watching on direct and then on cross-examination, I believe it was on direct, I apologize, it was being asked questions about the videotaping, the reenactment
Yes,
that
sir.
occurred on the 27th. You recall that between defendants when you took him back out to the scene? You recall that?
Yes, sir.
Okay. You were present for that, is that correct?
Yes, I was.
Okay. And do you recall that at some point the defendant walking, as he's walking, and he's walking the route where he claimed he went? You recall that?
Yes, sir.
Okay. And you recall him at some point saying that he went to look for an address and there were no addresses to the left there because those were the back of the buildings. You recall that?
Yes, sir.
That's what he said.
Okay. And I'm going to try to key to this point specifically, but do you recall?
I think I told the opposite of that.
I'm sorry.
You said, are you following? For a street sign, right? So I got out of my car and I started walking. Go ahead. Oh. I was still on the phone with non-emergency and I started walking. Okay. And because I didn't see a street sign here, but I knew if I went straight through, that's Retreat View Circle, and I could give him an address, because he said, just give me the address of the house here in front of me. And there's no address, because this is the back of the house.
Oh, but there's one right there
You recall
because
that
that's the front of
testimony,
the house.
Yes, sir, I do.
Sir, do you recall?
I don't know an address. And then they asked me where he went, what direction he went, and I said, I don't know. And then I thought to get out and look for a street.
Right there on that corner lived Miss Lauer. You recall that?
Yes, sir.
You get that in the photograph. I want to show you a photograph of the front of Miss Lauer's residence.
And
Isn't
she
there a medical
said
address right there
the
in the
truck
front of
is
the house?
right
Yes, there
there.
is.
It's in the fucking way. It's dark. You twat waffle. God, you're annoying.
Isn't her address 1211? Sir?
Yes, sir.
How good are your eyes? Bitch.
So as the defendant, hold on, stay right there on that photograph. So the defendant in that reenactment, when he's pointing at all the back of these houses, where he's claiming he doesn't have an address, there's an address right there staring at him. Isn't that true, sir?
Yes, there is.
That would be leading. Is this still redirect?
I'll be glad to rephrase the question. When a defendant turns and points on video to this side where he's saying there's no address because it's the back of the house, right to the right, what is there? Is there a house there with an address?
Yes, there is.
We go to the exhibit. For the record, that was State Exhibit 33. Just number 1. And let me show you State Exhibit number 1. And I'm going to put a close-up of part of that. For the record, State Exhibit number 1, that's an aerial photograph of the retreat of Twin Lakes, correct?
Yes, sir.
And as you pointed out when you used Mr. Romero's words, challenging the defendant in that interview, you pointed out there was only 3 actual streets in the whole neighborhood, correct?
Yes, sir.
And this street the defendant claims he did not know is Twin Tree Lane, which is the main entrance that you come in and out of that retreat of Twin Lakes. And right here, I'm pointing to is Ms. Lauer's address, correct?
Yes, sir.
So the defendant, when in that interview, claims he did not know this street and didn't happen to see the address here, but specifically did not know this street, correct?
Yes, correct.
Okay. Thank you, Your Honor. You recall also on cross-examination, defense counsel asking you about inconsistencies or consistencies, correct?
Correct.
Do you recall the defendant in the interview that he gave you and Investigator Singleton stating that after he had shot Trayvon Martin said, oh, or something, put his hands up, correct? Do you recall that?
Yes, sir.
And do you recall that he then stated that Trayvon Martin somehow fell on the ground face first? You recall that?
Yes, sir.
And do you recall the defendant stating that he put his arms out, correct? Do you recall him saying that?
Yes, sir.
Now, sir, come here first. Do you recall, sir, that one of the first, in fact, the first person that actually came out before the officer was a person named Joe Manalo?
Yes, sir. Jonathan.
I'm sorry. Jonathan Manalo, I apologize. And may I first witness, Your Honor? Showing you State Exhibit 77. Do you recall that he took some photographs out there?
Yes, I was. Yes.
And one of them was State Exhibit 77?
Yes, sir.
And may I publish that to the jury, Your Honor?
Yes, ma'am.
And you recall in that photograph, the victim's hands being underneath his body?
Yes, sir. Yes, sir.
Could someone say that that was inconsistent with the defendant's statements that his hands were straight out, that he had put his hands out?
That positioning, yes.
I'm sorry.
That positioning as seen there, yes, it is.
Talk to this man.
In that interview that you conducted, or Investigator Singleton conducted, the defendant didn't say, I put his hands out, and then after I put his hands out, I put him back in, did he?
No, he did not.
I think in cross-examination, you were asked something about exaggeration. Do you recall being asked about that?
Yes, sir.
And do you recall, I think either you uttered it or Mr. Romero uttered it on behalf of the defendant, exaggeration. Do you recall what that was about?
Pertains to the defendant's statements,
You felt he was exaggerating certain parts of it?
among other things.
Did you feel, I can't lead you, so
Okay.
did you feel in terms of exaggeration, what did you mean when you said that he was exaggerating parts of his interview?
How I felt, okay, based on,
Okay, no, what I'm getting is inconsistent. I don't want to give you,
okay.
you were asked specifically about exaggeration. Did you feel he had exaggerated the manner in which he was hit?
Yes, sir. Yes, sir.
Regarding your interview with the defendant on February 29th, was your investigation still ongoing?
Yes, it was.
Okay. Had you, at that point, and even further, had you gotten any results back from FDLE regarding the analysis done of the clothing or anything else regarding that, sir?
No, sir, I had not.
Had you gotten the medical examiner's report or examination in terms of final findings regarding that?
No, sir, I had
Had
not.
you gotten any results regarding possible DNA?
No, sir.
Had you gotten any results in terms of the ballistics, the firearms, the trajectory, the stippling, whatever evidence regarding that?
No, sir.
Had you spoken to a girl or lady that was speaking to the victim on the phone at the time or right before the time that this murder happened?
No, sir.
Had you analyzed the phone records and the conversations between the victim, Trayvon Martin, and this lady that he was speaking to? Her name's Rachel Gentile.
No, sir.
Had you seen the 7-Eleven video?
No, sir, I had not.
You also did, obviously, reports in this case, correct?
Yes, sir.
And in some of those reports, did you in some way write down some inconsistencies, what you felt were some inconsistencies based on the statements that the defendant had given you?
Concerns of mine about his statements, correct? Yes, sir.
Okay. You mentioned at some point or you were asked about the size of the individuals, correct? Mr. Martin and the defendant, correct?
The physical size is?
Yeah, I'm sorry, the victim.
Yes.
And I think, did you describe, I apologize if I got it wrong, did you describe the victim as a skinny kid or something to that effect?
Yes, sir, I did.
Would you classify the defendant, when you came into contact, as a skinny kid?
Would I classify the defendant as?
Yeah, as a skinny kid?
No, sir.
What?
Would it be fair to say the bottom line, sir, is that after February 29th and after a later date, the investigation was turned over to somebody else, is that correct?
As of what date, sir?
After that interview, at a later date in March, the investigation was turned over to another agency?
Yes, sir.
So Mr. O'Mara asked you about phone calls that you had, telephone conversations with the defendant. Do you recall that?
Yes, sir.
Okay. Was your intent to eventually, if you could, attempt to interview the defendant again and challenge him, I guess to use Mr. O'Mara's words?
Absolutely, yes, sir.
If I can have a moment, Your Honor.
Yes, ma'am.
I have a further question.
Thank you. Any requests?
Yes, Your Honor. Let's now go through some of the areas that Mr. Delaronde talked about. Starting with, and again, I'm going to give a blanket apology for using some curse words, but when they exist in the case, they exist in the courtroom. So Mr. Delaronde was wondering whether or not you would use the term assholes in inviting somebody over for dinner. I think he said probably not. However, would you agree that if you were talking to somebody about something that you've used the words assholes probably thousands of times in your life?
I have used it.
Okay.
Yes.
And sometimes it's just used as just a slang term. Would you agree?
Yes, sir.
When Mr. Delaronde said those words to you, I think he said assholes, didn't he?
And that's on
Yeah.
person.
Did you hear my client say that word assholes on the tape? We can play it again.
I heard him say it.
Okay. He didn't say it with the screeching voice that Mr. Delaronde did he?
No, sir.
He just sort of said assholes, right?
Yes, sir.
Did that, the way he said it, not the way Mr. Delaronde just said it, let's put that aside for a minute and speak more importantly about the way my client said the word assholes. Did that give you any cause for concern as to the way he said it?
No, sir.
Didn't show any ill will or hatred or spite when he said these assholes always get away? Did it?
If I may, not towards the individual, it seemed like more of a generalization.
Sure. Right. And of course, he was generalizing a little bit, correct? Because you know from your investigation that he was a bit frustrated that his neighborhood was being assailed by burglars, right?
That's how I
You
interpret
knew
it.
that.
Yes.
You knew that. As a matter of fact, you investigated and found out that a person, Emmanuel Burgess, was arrested 2 weeks before this event, a young black male, having burglarized several homes in the neighborhood, right?
Yes, sir.
Late teens, tall, thin, just been arrested, right?
Yes, sir.
Sentenced to 5 years in prison for having burglarized a bunch of homes both in Retreat View Circle and outside, but still in your jurisdiction, right?
I wasn't involved in that, but yes, sir.
But you found that out and looking into everything that you were looking into to see what's going on in the neighborhood, you knew not only had Emmanuel Burgess been arrested 2 weeks before for burglarizing, but that there were a lot of other burglaries in that same neighborhood, right?
Yes, sir.
Were you concerned that he was concerned about that? Did that cause you any concern that somebody who involved themselves in protecting the community, saying being on neighborhood watch, would be concerned about a bunch of burglaries in the neighborhood?
Him being concerned, if I may, is one thing. As far as my personal feelings towards his actions the night of, is a little bit different.
Sure, and we'll get to that in just a moment. But
No,
but
you can't talk about
talking
personal
specifically to the
feelings.
issue of calling them these assholes always get away. Were you concerned that you used the word assholes?
Appropriate.
And you've used it yourself,
Yes, I have.
and not in a necessarily derogatory way, correct? This is sort of a slang term.
It tends to work towards derogatory, sir.
So ever for guys walking into the squad room about dinner time and go, okay, what are you assholes doing for dinner? Anything like that?
Personally, no.
Really?
Not that. I see what you're saying, but it could be viewed that way.
Okay. Just like when you use the word shit, right? Oh shit, he's running.
Yes, sir.
Any concern with that slang term?
No.
Don't suggest that that evidences any hatred or ill will on his behalf to you?
As I interpret that, that was said with the infliction as a sense of urgency.
Yeah.
As if something was happening bad.
Right, because he was just running away, correct?
Yes.
And then let's talk about fucking punks. Were you here for John Guy's opening? Did you hear it?
No, sir.
Oh. When Mr. Zimmerman said the words fucking punks, did he say it in a screeching, loud, aggressive voice the way Mr. Delarionda just recounted it to you?
No, sir.
Do you know why Mr. Delarionda yelled it at you?
To stress a point, to emphasize.
Right. But you heard it on tape, correct?
Yes, sir.
And how was it said on tape?
This said as more as a matter of fact, look, as far as these assholes always get away. It's or
Fucking
fucking
punks.
punks.
Right. Might show some frustration, correct?
Yes.
Okay. Frustration based upon the fact that other people in the neighborhood who have burglarized the place seem to get away on occasion, right?
Yes.
And in that sense, you said that there was no evidence that Trayvon Martin was doing anything wrong, correct?
None whatsoever.
You don't know that, though, correct?
No, I do not.
Right? You know that whatever he may have been planning to do just wasn't completed, correct?
I wouldn't know. I wouldn't know. There was no evidence to suggest that at all.
Matter of fact, there was a type of a tool found in the area where Trayvon Martin may have been hiding, wasn't there?
Approximately 5-6 days after the investigation.
Right.
Yes.
When we went back and you looked in the bushes and you found, what was it?
It was a piece of an awning belonging to, it was, I believe it was a piece of a window, piece of hardware, basically. It looked like a Slim Jim.
Slim Jim. And what's a Slim Jim?
Slim Jim was a device used to go ahead and jimmy locks on vehicles primarily.
To break into a vehicle.
Yes, sir.
And that was found a few days after this event.
Yes, sir.
Not particularly tied to this event by you, but it was there, wasn't it?
Yes, it was.
In the bushes just off of one of the residences, correct?
In the bushes behind Jonathan Manolo's residence.
So, would you suggest that the focus be on how Mr. Zimmerman stated the words fucking punks as opposed to the way Mr. Guy did in opening or Mr. Delarionda just did in your questioning?
I can't speak for Mr. Guys, but Mr. Delarionda, it was different.
Okay. Now, he also asked you that you were questioning Mr. Zimmerman on the fact that he was following Trayvon Martin, correct?
Yes, sir.
And Mr. Zimmerman said,
Words along.
he said yes, right? He said, wait a minute, were you following him? And in the interview, his word was yes, right?
In one of the
He
interviews, yes.
acknowledged to you that he was following him at one point, correct?
Yes, sir.
Anything wrong with following somebody like that? Let me ask
That,
it this way, anything illegal? I'm sorry, I'll let him answer that one.
repeat it, please.
Anything, did you think that there was anything wrong with him following him to see where he was going?
Legally speaking, no.
Okay. Matter of fact, it was, and you heard the non-emergency call, right?
Yes, sir.
Okay. And it was twice on that the non-emergency operator asked Mr. Zimmerman, tell me if he does anything else,
Yes, I believe that was said.
right?
Yes.
Does that indicate that he wants him to keep an eye on him?
Yes, sir.
And you said following him is not legally improper, correct?
That's not illegal. No,
Even
sir.
approaching somebody is not legally improper, is it?
That's open for interpretation.
Tell me what crime you believe would occur if I were to walk up to you on the street and say, hi.
In that manner, none whatsoever.
How about, what are you doing here?
None whatsoever.
How about, get the hell out of here?
None whatsoever.
How about, I don't like the way you're dressed. I don't like the fact that you have gray on. Get out of my face.
That could be construed as confrontational.
Sure, but is
Not
that
illegal.
crime?
No, sir.
And when this operator who said twice, tell me if he does anything else, then says, are you following him? What does Mrs. Zimmerman say?
He says yes.
And in your investigation, is there anything at all to suggest at that time that Mrs. Zimmerman continued to follow Mr. Martin?
At which point, sir?
At the point that the officer said, or the 911 non-emergency operator said, we don't need you to do that, and Mrs. Zimmerman said, okay.
I would say yes, there
And
was.
what evidence would you have?
His end location.
I'm sorry?
His end location, the location where the incident ultimately ended.
Okay, so the fact that, may I approach the witness, Your Honor? For the case purposes, is stated at 139. Because you know the event started where?
The event, as far as I'm concerned, started off that map.
Okay, I'm talking about the physical altercation, I apologize. My understanding from, well, what's your understanding as to when Mr. Zimmerman got to this area, what path he took?
Okay.
Please do.
Could you face forward?
Yes. Okay. My understanding of the interpretation is he's coming this way. He walks. So I got a pointer. Okay. He walks for his statement all the way over here. He says he doesn't see him. He says he doesn't see him. Okay. And the altercation, physical altercation started right there approximately.
Okay, great, thank you. So with that as context, then, do you know exactly where Mr. Zimmerman was when the non-emergency operator said, we don't need you to do that?
Based on his statement, he was at his vehicle, which would have been, I believe, off of that or wherever he parked it. Wherever he parked it on Twin Trees.
It's your understanding of the investigation that Mrs. Zimmerman was at his vehicle when the officer said, we don't need you to do that?
That was when he was exiting his vehicle. That's my
Okay.
understanding, yeah.
Okay, and then how many seconds went forward as he was walking before that conversation occurred?
I have to,
Facts, not an evidence, because he's walking.
Sustained.
How many seconds? You heard the tape where you can hear him getting out of the car, correct?
where I heard the sound of the door being opened, which I interpreted that.
That he got out of the car,
Yes.
right? And then you know that he was walking in some direction because he said to the officer in response to, are you following him? He said, yes, right?
Objection is the facts, not an evidence, walking, assuming a fact, not an
Rephrase
evidence.
your question.
You know that he was following him because he told the non-emergency operator that he was, right?
Yes, sir.
And you know from the conversation that Mrs. Zimmerman indicated to the non-emergency operator that he had cut between the buildings, right?
Yes, sir.
Okay, so I might approach again, so just a little more clear with what you just testified to. He parked his car somewhere in this area, correct?
Correct.
And then, go ahead,
Like right here somewhere.
right?
So I'd have to hear it again, obviously,
Could you
but
face forward?
I'd have to hear it again, obviously, but somewhere very shortly thereafter leaving his car, that's when it was asked, are you following him?
Okay,
And he said, yes.
and Mrs. Zimmerman indicated that Mr. Martin had gone between the buildings, it was out of sight, correct?
Yes.
Yet, you testified a moment ago that pursuant to Mr. Zimmerman's statement, he had gone down to Retreat View Circle, correct?
Well, that was his statement, but as far as him having a visual on when he might have got out of the vehicle, I really don't know. I can't say. It wasn't there. But he could have seen him at any point which way he was running. Am I making myself there? I mean,
Well, the jury can decide. I'll try and walk you through a little bit more. So my question a little while ago was whether or not you had any evidence to support any contention that Mr. Zimmerman continued to follow Trayvon Martin after being told not to. Do you have any evidence to support that?
I would answer, I have information, yes, that there was, just based on where we located Trayvon and the fact that the altercation happened after his conversation. That's my interpretation.
Let me
that
ask it
there
this
was
way.
some.
Let me ask it this way. Do you have anything to contradict Mr. Zimmerman's statement that he walked the rest of the way to Retreat View Circle and was coming back towards his car when the interaction, whatever it was, between Trayvon Martin and him occurred?
Nothing tangible, no.
Go intangible on us then. What do you mean nothing tangible? What do you have?
And the circumstances, the totality of the whole thing that I'm looking at, as I interpreted it, when he says follow, walking behind, trying to find a direction, I construe that as follow. he was trying to do something in the same direction where Trayvon was going.
He was trying to see where he was.
As far as the word follow, as my report may indicate, I mean, it's, but it's open for interpretation.
And as your report indicates, there's nothing to suggest that Trayvon Martin went straight down Retreat View Circle, towards Retreat View Circle. He went between the buildings, correct?
According to statements made by Mr. Zimmerman. According to statements made by Cleveland, yeah.
And of course, all of those statements, including Mr. Zimmerman saying that he was attacked by Trayvon Martin coming from that area as well, correct?
Correct.
Anything to contradict that?
No, sir.
Oh my God.
You understood from your conversation with Wendy Dorval, your knowledge of Neighborhood Watch, that if a crime is occurring, that you ought to call 911, correct?
I don't recall talking to Wendy Dorval about it, but I may have. But yes, that's what you do.
So if it's just a concern, like a suspicious person, you dial non-emergency, correct?
Yes, sir.
And if it's an actual crime occurring, you dial 911.
If those are the instructions, yes.
And which one did Mr. Zimmerman dial?
The non-emergency.
Evidencing, would you agree that he was not concerned that a crime was actually occurring, just that he was concerned about somebody being where they may not supposed to be?
Yes, sir.
May not supposed to be.
And in your experience
Can't
and
word right
knowledge, did you think it was inappropriate for Mr. Zimmerman to call non-emergency when he saw Trayvon Martin hanging out between two homes in the rain, in the dark?
Objection is calls for speculation on his part.
Sustained.
You want to ask you for his, okay. In your opinion, I don't want you to speculate as to what, but in your opinion, was that an appropriate, from law enforcement experience, was that an appropriate occurrence for him to contact non-emergency based on seeing somebody who he didn't know at night in the rain between two homes, not walking away, just standing there?
My objection is to assume that those facts are accurate and truthful.
The jury,
Okay, you can answer the question.
That would be reasonable to
Reasonable,
call
correct?
non-emergency.
in fact, if you were driving an unmarked car past that at that precise moment and saw Trayvon Martin there, standing between two buildings at night in the rain, not moving, maybe even looking into a window, would you have stopped and talked to him?
Not just based on his presence. No, I would not.
And why not?
He might live there.
But the question is, would you stop and ask him?
Not just based on what you observed, no.
Do you agree that police, at least, are supposed to look into situations that might be suspicious?
If brought to the attention by a citizen, yes.
I'm sorry?
If brought to the attention by a citizen, such as
Oh.
George Zimmerman, yes, we are obligated to.
So you wouldn't do it on your own?
If on routine patrol, I can't say, maybe.
Mr. De Leon asked you that if you had found out whether or not Trayvon Martin was armed, correct?
Yes, sir.
Do you also realize from the investigation, presumably for a moment, that Mr. Zimmerman's story is completely accurate and that he did in fact receive the injuries to the back of his head at Trayvon Martin's hands, that Trayvon Martin was smashing his head, hitting his head against concrete, correct?
Yes, sir.
Do you consider that to have armed himself with the concrete?
Yes, sir.
So though he may not have been armed when he was walking, he certainly armed himself with something that could cause great bodily injury or death by hitting the head against concrete, correct?
Yes, sir.
And in the challenge interview, and we go back and forth as to whether or not it was an interview with challenge, an interview for information, but again, for these purposes, calling it a challenge interview. Mrs. Zimmerman stated to you that his concern was that there were people who are out there, quote, victimizing the neighborhood, right?
Yes, that's what he said, yes.
And do you believe that his basis for that thought or even that feeling was well-founded? Let me ask it this way. How many burglaries had occurred in that neighborhood in the past 4 or 5 months?
I don't have the exact numbers, sir.
Would you consider it to be a rash of burglaries?
It would depend how many we're talking about. I don't know.
Well, limiting to the extent of what you looked into. I know you looked into Emmanuel Burgess, and he was arrested a couple weeks before. And there were other burglaries that you were aware of, correct? Within the last few months before this event?
I'd have to refresh my memory as far as the number, to consider it a rash of burglaries. To consider it a rash of burglaries or a crime spree, I but I guess in his mind, yes.
And of course, burglaries are what occur when the people are not at home, correct?
Repeat, please.
A burglary that we're talking about now are those where the people are not at home when the crime occurs, correct?
Correct.
It's called burglary of an occupied dwelling or home invasion when somebody's home, correct?
Yes, sir.
And that happened here as well, didn't it?
Yes, sir.
A woman, and you were aware in your investigation that a woman and her, I think, 4-month-old child had to hide in a bedroom closet while two guys downstairs took out her TV, laptop, and other items.
Yes, sir.
And that was only weeks before February 26th of 2012, correct?
Yes, sir.
And it may have been months before, a couple months before, if I said weeks.
It had occurred, though.
Concerning the videotaping, and I can put you back to the tape, my memory, and tell me if I'm wrong, was that when you were bluffing Mr. Zimmerman about the idea that Trayvon Martin may have had a phone that was videotaping things, you certainly did it in as believable a way as you could, remember?
Yes, sir.
You know how to get it across to him, correct?
Yes,
He
sir.
seemed smug, as though he already had made this decision. Well, you can try and bluff me if you want, but I know he didn't have his phone out. Was there any of that came across to you?
No, sir.
In this challenge interview, was that exactly what you were looking for to see?
Partially, yes.
And none of that came across to you, did it?
None at all.
Matter of fact, he seemed quite interested in the fact that there may have been a videotape, correct?
Yes, he did.
Didn't he also say that he, maybe without his knowing, he'd hoped that the Homo Association had put up another video camera somewhere in that back area?
Yes, he did.
So he actually said to you, not only do I hope that Trayvon Martin was somehow taping this, or since he had the phone out or whatever, that somehow maybe it was on video. And he said, what was his words? Thank God. I hope it was videotaping.
Words to those effect, yes.
And he even said to you, well, maybe it's being videotaped from somewhere else. That maybe the Homeowners Association had put up a camera going right down that dog walk that I wasn't aware of, or for that matter, any one of the dozen neighbors may have had a video camera out, correct?
Yes, sir.
Didn't he also indicate that he even hoped that maybe the one person who had come out, who we now know to be John Good, that maybe he had videotaped it?
I don't know if he verbalized that, but he seemed to be very open to having something videoed. Yes, he seemed to be very elated in the prospect that there was some sort of videotape.
Hoping that that would actually document what happened that night.
Yes, sir.
Another challenge that you did, another
Oh my goodness.
What did I do? A complete pirouette.
You good, bro?
Thank you. Another challenge that you did to Mrs. Zimmerman
There.
was concerning this question about the hands over the face, correct? Because
Yes,
that was
sir.
a concern of yours, right?
Yes, sir.
He said he placed his hand over my face at one point. I really thought he was suffocating me. Words like that, correct?
Yes, sir.
And yet, on the screaming of the 911, there wasn't a great deal of muffling. Would you agree?
No, sir, there was not, yes.
And had there been muffling, then it would have even been perfectly coordinated with what Mrs. Zimmerman told you, because then the suffocating, muffling would have shown up on the tape. But in this case, it didn't, correct?
Correct.
You agree that the screams are
Happened
from one
prior
person,
to-
correct?
Based on interpreted, yes.
Okay.
Yeah.
And that they were just that, screams, stop, scream, stop, scream, stop, correct?
Yes, sir.
Okay. And I think you said that you also believe Mr. Zimmerman may have exaggerated as to the number of times getting hit, correct?
Yes, sir.
Mr. Delagnano brought that up again as an exaggeration, right?
Possible, yes.
Yeah, I think we talked about it as to how it might be perceived when you're the one getting hit, correct?
Yes, sir.
Okay. May also be that you perceive getting smothered even when somebody has your hand on their broken nose.
Possibly, yes.
Okay. May have actually had a hand on his mouth or nose, but just not enough to interfere with Mr. Zimmerman's continued screams for help, correct?
Correct.
So even though you challenged him on that to try and come up with an answer, and he told you, I don't know, right?
Correct.
Did you change the story at that point, realizing that now you got him on a fact, and just say, well, actually I turned over and I was screaming the other way, and that's what? Did he do any of that?
No, sir, you're not.
He just basically said, I think he had his hands on my head, right?
Yes, sir.
I think he was trying to stop me from
Yes, sir.
breathing. And it hurt.
Yes, sir.
And just so we're clear in that regard, would you agree that there may have been some screams muffled enough so that they simply didn't show up on the tape?
That could have been possibly.
With that last challenge, call it the suffocation challenge, was there anything in that challenge of Mrs. Zimmerman that you thought then was problematic? The way he answered it?
No, sir.
And let's talk about the video where Mrs. Zimmerman seems, maybe for the second time, to not notice Ms. Lauer's number on the right-hand side, correct?
Yes, sir.
And as he's walking you through it, again, voluntarily doing what you wanted him to do, right?
Yes, sir.
No. Don't do that.
He sort of looked over and he said, I didn't see anything here.
Yes, sir.
Would he have seen them if he had just started walking by and just got past Miss Lauer's, the front door right there? Is there any number on the side of that building?
No, sir.
Okay. So if I might carefully approach you on again. Just so we're clear on, again, states 139. This is Miss Lauer's, front door here.
He would like.
Number is sort of on this side.
Yes, sir. Facing the street.
Right, facing out this way.
Yes, sir.
So if Mrs. Zimmerman had gotten to this point, or was looking around, doing whatever he was doing, as soon as he got to somewhere in this point, he would not have a line of sight to
I'm
those.
going to object to Ms. Ferris misstating what Mr. Zimmerman said on video as to where he was when he didn't or did see the address.
Okay.
I'll clear that up.
Rephrase your question.
No one could see the numbers once you get past this, correct?
Correct.
And you do agree that Mrs. Zimmerman was trying to do the best he could to acknowledge what he was doing in the recreation, correct?
By appearances, yes.
He seemed to be doing everything that he could to explain to you what he was doing.
Yes, sir.
As he was doing this, was it a situation where you just sort of letting him run with it, or were you asking him any questions along the way?
I believe some questions were asked for
Yeah.
clarification.
Sure. And when he said, as he's walking with Miss Lauer's to the right of him, and he's sort of looking this way, the car is somewhere near where he said he parked his, right?
From what I recall, yes.
And you had the non-emergency call already known by the time you did the recreation. So you knew an idea of the series of events, correct?
Yes, sir.
You knew that he had said that I'd gotten out of the car about here, right?
Yes, sir.
And that he was walking down that
Excuse me.
road, doing something, walking, running, jogging, whatever he was doing. He was ambulating down that path, correct?
Yes, sir.
Then he sort of looked over and said, I couldn't see any numbers. And he looked to his left, correct?
From what I recall, yes.
Yeah. Did anyone ever think at that point to go, excuse me, you back up and look over this way, there's a number. Why didn't you look at that number?
If it wasn't mentioned, no.
Did you ever do that afterwards?
No.
Did that seem, in the context of what he was trying to explain that happened to him that night, that ended up with what it ended up with, that was some type of active deception to you?
I didn't interpret it as such, no.
Okay. I mean, it doesn't make a lot of sense in your mind that he couldn't remember the name of the street, correct?
Correct.
If you said there's only 3 there, correct?
Correct.
And you even questioned him about that, right?
Yes, sir.
But did that show to you to be some active deception on his part?
The fact that he couldn't remember the 3 streets could have possibly, yes, it did raise flags and concerns.
Okay. And did that lead to any concern? I mean, you addressed it in this confrontation interview, correct?
Yes, sir.
And you okay with what he responded?
That's all I could do is be okay with it.
And then you were questioned about a number of things concerning the investigation. So I want to talk to you about some of those.
Okay.
The medical examiner's report. You had a chance to review that, correct?
Yes, I have.
Okay. And medical examiner's report and its findings were consistent with Mrs. Zimmerman's story, were they not?
Yes, sir.
Okay. As far as how he shot him, correct? Where he shot him?
Yes, sir.
And the distance between the muzzle of the gun and the clothing, correct?
Yes, sir.
And also that there was a gap of a few inches between the clothing and Mr. Martin's chest, correct?
Yes, sir.
Evidencing that though the muzzle of the gun was up against the chest, up against the shirt, that the shirt was not up against the
Not an
chest.
evidence yet.
But there was a
I
few
haven't
inch
seen the medical
difference.
examiner.
Yes, sir.
Right? And didn't that support the contention that Mr. Martin was hanging over Mr. Zimmerman, his shirt coming forward when the shot was fired?
It did.
Right?
Yes.
Because had he been standing up, as I am now, the shirt would be up against the chest, probably, right?
Probably, yes.
And if I lean over, my shirt is going to fall apart from my chest a few inches, and that seems to be how it was, correct?
Yes, sir.
The medical examiner's report, however, does not support a contention, an allegation, that Mr. Zimmerman pressed that gun against Trayvon Martin's chest before he fired it, does it?
Not from the one.
Matter of fact, the known evidence completely contradicts that type of a suggestion, doesn't it?
From what I understand, yes.
So
Interesting.
no pressing of the gun against the chest, was there?
Not based on evidence that I've read, no.
Gosh, dang it, Babby. Does the defense even
And
have to put on a case?
you saw the 7-Eleven video since, right there. I think Mr. DeLeon suggested you didn't have it then. You've certainly seen it since.
I don't think I viewed the video itself. I think that was bought after I was,
No, but have you seen it?
I've seen stills,
Okay.
still photos.
And the stills that you saw show Trayvon Martin in it
Yes, sir.
and show him the way he appeared that night.
Yes, sir.
So when you say that certainly in the autopsy photograph that you wanted to show Mr. Zimmerman, which again was part of the challenge interview, correct?
Yes, sir.
You hit him with something sort of emotional and to ground him that he had caused the death of this person?
It was graphic, yes, sir.
That's the purpose of it, right?
Yes, sir.
But the picture of Mr. Martin at 7-Eleven, would you agree that that shows somebody at his height, whatever that might have been, in the shoes and the hoodie, and wearing the outfit that he was wearing, that he did not look in the 7-Eleven video to be the skinny kid that you showed the picture of Mrs. Zimmerman, correct?
Correct.
Much larger looking individual,
I would agree with you, yes.
my height or so? I'm
Correct.
6'2", right?
Yes,
If I was wearing a hoodie and had his shoes on, correct?
yes.
When you talk about relative size, although I think you said that Mrs. Zimmerman, not today, but back then, wouldn't come across as a skinny kid, correct?
Correct.
When you look at the actual height differential, there was quite a height differential, wasn't there?
Yes, there was.
And therefore a reach differential?
Yes, sir.
You know what that means, right?
Yes, it is.
What is that?
The reach is measured arm to arm, sideways.
Sorry, you can reach out in front of you.
Come and have a moment, Norm.
George had T-Rex arms. Trayvon had long arms. George is short. No more questions.
Thank you, Mr. President.
Thank you. Any redirect?
Yes, Your Honor.
Of course.
Just on the very end,
Has
would you
work.
agree that after somebody dies, they don't get taller?
Excuse me, I'm sorry.
Have you ever heard of when people die that they get taller?
Oh, no, sir.
Jesus fuck.
So you're not disputing, the medical examiner would say, they measured him on a table, that Trayvon Martin was only 5'11". You're not disputing that, are you?
No, sir.
I mean, you're not trying to tell the jury that after Trayvon Martin died, he grew to be 6'2",
No,
are you?
sir. No,
I mean, have you ever heard of that? Somebody dying and growing taller?
no, sir.
Okay. And by the way, Mr. Romero asked you, I want to make sure I understood your answer. Are you saying that in Seminole County, it's against the law for somebody to wear a hoodie at night?
Objection, Your Honor. That is a mischaracterization of the evidence in my question.
Okay, I think you need to rephrase it because you started.
Are you saying that it's against the law for a person to wear a hoodie at night?
Are
No,
you
sir.
fucking kidding?
No, sir. No.
I believe in your investigation and your interview with the defendant, that he had a phone, correct, that night?
The
When he
defendant?
observed the victim, Trayvon Martin? The defendant had a cell phone,
Yes, he
right?
did. Yes.
You didn't find any evidence of the defendant, when he's claiming he's seen the suspicious activity, videotape or photograph the suspicious activity that he claims the victim was doing.
The objection,
Was there any evidence of that?
Just a second. What's the objection?
outside the scope of recross, unless we're opening up that new area.
No, overruled. It's not opening it up.
You were asked about videos, right? Was there any evidence to indicate that when the defendant claimed that the victim was committing a crime or was about to commit a crime, that he videotaped it since he had a phone with the ability to videotape or take photographs. Did he ever do that?
No, sir.
You were asked about this
Why would he?
item that was found behind some bushes. Isn't it true that was part of an awning that Mr. Manalo had there?
As part of his house, yeah.
Right? There was no
Yes,
evidence
sir.
to indicate that was used as a tool or a slim jam or anything like that.
None whatsoever.
And you would agree that an expert, or if he's qualified as an expert, a medical examiner or assistant medical examiner would be better qualified as to the findings that he made versus you saying what he said?
Yes, sir.
You would defer to a medical examiner, would you not?
Absolutely.
Why did you use air?
Mr.
quotes?
Romero asked you some questions about the burglaries that were being
Hard.
committed out there at Retreat Twin Lakes that you investigated or determined there was some, right?
Yes, sir.
And that the defendant had made calls about them, right?
Yes, sir.
Okay.
But do you see how friendly he is with him at first? And then when you see that he's not doing things the way he fucking wants him to, he turns into this little catty ass little bitch where he's going to be like, oh, well, they didn't. Well, is this what you mean? And is this what you mean? Bitch, don't twist my words. That's not what I said. You can miss me with all of that.
And I think Mr. Romero referred to it as a black male, right? At least one of them he referred to. Did you know whether the other individuals he had called on were black males or not?
From what I recall
Some
researching,
of them,
yes.
yeah.
From what I recall researching then, yes, they were.
Mr. Romero asked you a bunch of questions about the word, pardon my language, asshole. And did I understand you correctly to say that that is a derogatory term in describing somebody or referring to somebody?
In my opinion, yes.
And Mr. Romero asked you about the words that the defendant uttered on February 26th at around 7:10 before he followed the victim. Do you recall him specifically under his breath saying, pardon my language, these fucking punks? Do you recall that's the way he uttered it?
Yes, sir.
Okay. Now, do you read any comics?
Never what?
Do you read any comics?
Comics.
Comics? No?
No,
Now they have a little caption where they have like a little bubble because they kind of, what the person's thinking.
Yes, sir.
Fucking God.
At the time he got out of the car and was getting out of the car, defendant said the words, these fucking punks, pardon my language, right?
Yes, sir.
And then he followed Trayvon Martin, correct?
Yes, sir.
Mr. Romero asked you a few questions about suffocating. Do you recall being asked questions about that, suffocating?
Yes, sir.
Now, the defendant claims that the victim was suffocating him, correct?
Yes, sir.
Okay.
That's what
Did
it
you find any
felt
evidence
like
of blood on the victim's
to
hands?
him.
None that I'm aware of. No, sir.
And there was evidence that the defendant was bleeding, especially on his mouth, right here on his mustache. He had some, right under his nose, he had some blood, correct?
Yes, sir.
May I approach the witness, Your Honor? I'm not going to hit you, but
You hit me. It's
if I can, and I'm hitting you, correct?
Mhm.
That's what the defendant's claiming, that I'm suffocating you and I'm not going to put my hand in your mouth.
That's fine.
Would you have your hands like that, just like this? Or would you be fighting me?
I'd be fighting you. I'd be fighting you. Make sure you got that.
Did you find any blood or anything on the defendant's hands?
No, sir.
You were also asked about witnesses and stuff. And if I may approach the witness again. State Exhibit 140, Mr. Romero showed you this. You recall this? And he asked you in terms of assuming, and I apologize, he may have actually shown you 139. I apologize. Let me take those up so that. $139, he asked you about assuming the defendant's story is correct in terms of where the altercation had, et cetera.
Yes, sir.
Did you have some evidence that possibly there was something going on behind these houses here, the Bahador's house?
Yes, sir.
You're so smart. You're so smart, Charlie Brown.
You were asked about the hoodie at the 7-Eleven. I'm not aware of, but what law states that an individual can't go into a 7-Eleven with a hoodie? Is there some law that I missed?
No, sir.
Who said that? Nobody said that. You twat. You're stupid. Good God. No more fucking questions. Sit down. Shut up, stupid.
And finally, you did not have the phone records in terms of Trayvon Martin or Rachel Gentile's, right, the lady you did not know he was talking to determine whether it was accurate based on when the defendant's phone finished or not.
No, sir, I did
In
not.
other words, you didn't have the defendant's phone records either, did you?
No, sir.
And I'm talking about on the February 29th interview. I apologize.
I was assuming that, yes.
Thank you. No further questions.
Thank you.
Good.
You know, we've been here almost 2 hours this morning on cross, redirect, recross, redirect. And now you're seeking to recross. I will give you 5 minutes. It's the state's witness, and the state will then have another 5 minutes on redirect.
No, let it go.
Sorry, there's just new areas going into, I have to address them.
Well, you have 5 minutes
I will take it.
for your
Yes.
recross.
Yes, Your Honor. Now, as far as any blood on Mr. Zimmerman's hands, of course, when he got to you, he was already cleaned up by EMTs and he had washed himself at SPD, correct?
Yes, sir.
You wouldn't expect to find blood on his hands at that point, would you?
No, sir.
And when the suggestion is, why didn't Trayvon Martin have blood on his hands? Is blood susceptible to gravity as well? Like
Yes, sir, it
things?
is.
So if he gets smashed in the nose and is thrown on the ground, which way is the blood going?
Towards the ground, and
And back down his throat?
back down his throat,
Right.
or,
And only when he stands up, is it going to start coming out of his nostrils?
yes, sir.
Which is after he's no longer being mounted by Trayvon Martin?
Typically, yes, sir.
Okay. So break my nose, put me on the ground, my blood's going backwards into my throat, right?
Theoretically, yes.
And would not be available to be on Trayvon Martin's hands at that point because there was no blood outside the nose, correct?
Correct.
And I'm not going to approach you like he did, but basically, first of all, let's use the left, if he's holding him down, could that be literally momentary that he's holding him down and that Mrs. Zimmerman is trying to get back up?
Yes, sir.
And could he attempt to suffocate literally be momentary as well?
Yes, sir.
Could it even be a sleeve or an arm or a palm or anything that could have given Mrs. Zimmerman that impression?
Yes, sir.
Thank you, Your Honor.
Thank you. You have,
I think I'm only going to ask 2 or 3 questions.
thank you.
May only ask one. Right now, it could be raining outside, right?
Yes, sir.
And that would be pure speculation on your part, would it not?
Yes, it would.
Thank you.
Thank you. Also, Serena, you're excused from the courtroom, but you're subject to being
Such a
recalled.
fucking smart ass.
Thank you very much.
Fucking twat waffle.
Ladies and gentlemen, I think we'll take a
Your
15-minute
witness
recess. If you'll please put your
that you
notepads face
just
down on the chairs
fucking
and follow
did that too.
deputy back into the jury room.
Good God. You put him up there to fucking speculate. So shut up. Like, that was you.
Last name.
OST.
Who are you? I hate you. I keep doing this. Let somebody else
You
fucking
seated?
do this shit. Oh my God. It is all.
You may, yes, you may.
Can you state your name for the record, please, sir?
Mark Osterman.
And could you spell your last name?
OSTERMAN.
And you work for a federal agency, sir?
Yes, I do. Federal Air Marshal Service.
Okay. How long have you been so employed?
Since December of 2001.
Do you know a person by the name of George Zimmerman?
Very well.
Okay. And is he seated here in the courtroom today?
Yes, he is.
See, the person just stood up.
Yes, he is.
Front of the record, reflect the witness identified defendant, George Zimmerman.
The record will so reflect.
And how long have you known him approximately?
At least 5 years.
Okay. And you knew him back in February of 2012, is that correct?
Yes, I did.
Okay. And would you consider him a very good friend?
Best friend I've ever had.
Okay. I want to draw your attention to February 26th, February 27th, the evening of February 26th, 27th. Did you get a call and you end up responding to the retreat at Twin Lakes?
I did.
And did you meet the defendant's wife, Shelley Zimmerman?
This should be
I did.
interesting.
Later the following morning, early morning of the 27th, did you come into contact with the defendant, George Zimmerman?
Yes, I did.
Okay. And did you transport him somewhere with his wife, Shelley Zimmerman?
I did.
Okay. Did he make some statements to you regarding what he alleged happened regarding the shooting he was involved in?
Yes, he did.
Okay. And did he specifically state that that Sunday night, the 26th, he had was going shopping at Target?
Correct.
Any objector on a reading?
Okay, if you could, tell us what the defendant told you, and let me set the setting if I could. You were with yourself, and I believe you were driving, is that correct?
I drove myself.
Okay.
You-
I apologize.
before-
I'm going to rephrase the question. I
Right.
apologize, confusing my part. When Mr.
not
Zimmerman, the
used to
defendant, was
not
telling you
being.
something about what happened, he was in the car with you, is that correct?
That is correct.
And were you driving?
I was.
And was his wife, Shelley Zimmerman, in the car with you and him?
She was.
Okay. And did he make some statements regarding what had happened regarding the shooting?
He did.
Okay, if you could tell us what the defendant said regarding what he alleged happened.
George said that on that Sunday night, he had left his home, as he did every Sunday night, to get lunches for the week. And as he was going to go to Super Target, which is really, really close to his home, he was going to, he just drives out of his neighborhood, and I think it was dark that night. And on his way there is when he observed someone in a black hoodie and someone who was looking like someone he had not seen before. And he knew most of the people in his neighborhood. So he had observed someone walking through the neighborhood with a hoodie on, looking either into windows or looking into around residences and such.
All right, let me interrupt you if I could. Did he describe the individual he said?
He did.
How did he describe him?
Tall, about 6 foot, and about slender build.
And he stated the person was doing something, you said?
He said as walking through between two sets of townhomes, when you look to your left and right, you would look into windows. You wouldn't be in a position really to look into either the front door or such, but it was side windows.
Yes, sir. Did he further describe the individual by race or ethnicity?
Well, at that time, he knew that he was a black male.
Okay. I apologize. I interrupted you. You said, what else did the defendant tell you regarding what happened?
He said then when he realized that the person that was walking through the neighborhood was someone he didn't know, he didn't recognize, and someone who usually looks through a neighborhood while it's raining, it's suspicious, because a lot of times juveniles will walk through neighborhoods or people who are suspicious will walk through neighborhoods while it's raining because you get less people walking around, walking their dogs, or just taking an evening walk. So someone who might want to be a little more suspicious, if they're acting suspicious, they'll do it when it's dark and when it's raining. And that might have been a trigger, he had said to me.
Okay. What I want to do is focus as best you can in terms of what you recall him saying as opposed to.
I'm sorry.
No, that's all right.
Yeah, he said he observed what is now we realize is Trayvon walking between the two buildings, and then he came down and he observed him, thought it was suspicious, and then he was going to call the non-emergency number for the Sanford Police Department.
Did he state that the individual that we're referring now as Trayvon Martin starts toward him and came under the light, and so he was using his phone?
Correct. George was using his. I'm sorry. Did you mention George was using his phone or Trayvon?
What did he say?
I was never told by George that Trayvon was using his phone.
I'm sorry, that
George was.
George, I apologize.
Correct.
George Zimmerman was using his phone.
Correct. He dialed the non-emergency number, and he wanted to make sure that he called that line instead of the 911 line.
If
Did
Charlie
he
Brown
say
would stop fucking leading the witness.
That Trayvon Martin approached this car?
Walked close at this point.
Okay, what does he say about that? If you could.
Walked down to the street about where, because George had remained in his vehicle, and Trayvon had walked down, I guess down to the sidewalk area, walked a little further away, walked back a bit, and then George had, I believe, pulled into the front of their clubhouse and parked his vehicle there and waited for Sanford Police to arrive and.
Okay, does he say, I apologize, I interrupted you, sir.
I'm sorry, just.
So shut the fuck
Did he
up.
say that the person you now know is Trayvon Martin? When I say he, I'm talking about the defendant, George Zimmerman.
Right.
That he walked up to the passenger side window and stood there for a moment, then goes to the front of the car, comes around to my window, my driver's side, then towards the rear of my car, then walks away?
Yeah, it was walked around at the vehicle.
He said he
Very
circled
in
the
a close
car.
proximity, and I think they looked at each other, George had said.
Did the defendant, then say that at some point then he lost sight of the person you now know as Trayvon Martin?
Yes, briefly.
And do you recall then in terms of Mr. Zimmerman, the defendant saying that he was talking to dispatch or to the non-emergency person, correct?
Yes.
And did he tell you that in terms of whether he was asked, are you following him? And he answered, yes, I'm following him, but he didn't see Trayvon Martin at that time, was looking for him?
Well, there's kind of two, as George described it to me, there were kind of two phases of the contact. The first one was when he first saw him, and then he pulled into the clubhouse parking lot. And then the second one was when he reestablished contact with Trayvon. He walked down another side street that wasn't the main street around the circle. And then he backed his car up, and then he tried to keep a visual contact with him, so he followed him with his car. And he didn't get out of his vehicle until he lost visual sight of him.
And then do you recall the defendant telling you that the officer or the dispatcher, I use officer just because they're with the police department, saying to the defendant that we don't need you to follow him, and he said, okay?
Correct. That was at the point where he had already gotten out of his car first. And as he described to me, there were two reasons for getting out of the car. First, he didn't know the street I guess he was on that center street. It's a smaller street. He didn't know the actual name of it. So he got out of his car to try to establish a visual contact, to try to direct the police officer in to meet with Trayvon and dispel his suspicions, and to find the exact address. Because as a police officer, you always want to know the exact address of where you're going.
All right, and then he told you, I'm sorry, the defendant, I apologize for using pronoun, that he started walking and then he put his phone somewhere.
He put his phone in his pocket after the dispatcher told him they didn't need him to follow him. So he was going to walk back to his vehicle.
Okay. And then he said something happened at that point?
He told me that as he was walking back to his car down the dog path, that Trayvon had confronted him, had walked towards him and confronted him, and they had a verbal.
Okay, and what do you recall a defendant telling you that Trayvon Martin told him, and what did he say in response?
He cursed. I'm not going to curse here today. He said, do you have a problem? And then he used a curse word.
All right, now, you wrote a book about this, right?
I did.
And you wrote a book and where you quoted what the defendant, George Zimmerman, told you, correct?
Correct.
And do you recall in that book writing, do you have a problem? That's what he said, Trayvon Martin said.
Right. Correct.
Okay. And you didn't put in that book anything about a curse word at all?
I believe I did.
You did? Okay.
I believe I did. Do you have a problem? And then he used the initials MF.
Okay. May I approach the witness, Your Honor?
Yes, I may.
I'm going to show you your own book. And unless I got the wrong page, I'm on page 28, counsel.
What is the point?
Just to refresh your memory.
Correct.
And don't read from it, you just, this
Okay.
is to refresh your memory.
All right. Yeah, he had told me that, do you have a problem? And then the curse word, it was taken out of the book because it was pretty graphic. And
Oh, okay, so you on purpose, you took it out.
I think the publisher had
Okay.
asked that not be put in.
Because you put on there, do you have a problem? And then Mr. Zimmerman, that you said, replied, no, I don't have a problem.
Correct. And it was at
But you believe the words were actually what now, the defendant said?
MF.
Okay, so these juries have heard, so just the record to be
Okay,
clear.
I just
He
don't-
said, do you have a problem, motherfucker?
Correct.
Okay.
Why
And
do you
then
have to make him cut?
the defendant,
Like,
Mr. Zimmerman,
why?
said in reply, no, I don't have a problem. And then Mr. Trayvon Martin replied,
You do now.
and the defendant claimed that Trayvon Martin was coming at him at that time?
He was very close, probably within an arm's or 2 arms reach,
Okay,
and George lost contact
And-
visually.
and I apologize.
Okay,
I
I'm sorry, go
interrupted
ahead.
you.
Go right ahead. No, he, as George was reaching down to get to his phone to reestablish contact with the dispatch, that's when physical contact happened.
So the defendant told you that he has these words with Trayvon Martin,
Correct.
and then he said that he went and reached for his phone in his pocket.
Correct. Looked down.
I'm sorry, he looked down.
He looked down to reach to get into his pocket,
And at that point is when Trayvon Martin hit him?
struck him in the nose.
Okay. So the defendant claims he
So
looked down,
far,
and that's when Trayvon Martin hit him.
Well, he looked down, got his phone, and he said as he looked back up, he lost visual contact for maybe a second. To get his phone out of his pocket, he went like this, and as he looked up, the punch came squarely in his face.
So did the defendant say he took the phone out or left it in his pocket?
I don't remember that.
Okay.
I don't remember.
And then what did the defendant claim after he claims the victim hit him in the nose?
He stumbled backwards and found himself on his back,
Okay.
partially on the grass, partially on the sidewalk.
Did he say what the victim, Trayvon Martin, was doing at that point?
He moved forward and got on top of him.
Did he describe to you how he got on top of him?
His knees were up somewhere near his chest or up near his armpits,
Okay.
and he was beginning to punch him.
Okay, so the defendant is claiming that the victim straddled him, I guess,
Correct.
and his knees were up in his ribs and near his armpits, correct?
Correct.
And he began punching him.
That's what George said.
And I apologize, he began punching Trayvon Martin. Okay.
Trayvon began punching George Zimmerman.
I'm sorry, I got it backwards, sorry. The defendant's claiming he's on the ground,
And
Trayvon Martin is straddling
was
him.
punching him. I'm sorry.
I apologize, Mr. Officer.
I'm sorry. He said that he was on his back and Trayvon Martin straddled him and began punching him in the face.
But the way he described Trayvon Martin straddling the defendant, he claims that you said his knees were up to his ribcage or armpits, is that correct?
Somewhere around there, correct.
Then he said, what?
Well, George began screaming for help at that point.
Did he say anything about the defendant grabbing his head and doing something with his head?
Absolutely. Once he started screaming,
What is the
Trayvon,
point?
George said Trayvon grabbed his head
We're
and started
hearing
bashing his head on the
story all
concrete,
over again
which
because he
his
told
upper
it
half
to
of his
another
body was
guy.
on the dog path.
Right. In fact,
You
I
told
think
it to
you
another
quoted
person.
Mr. Zimmerman
You told it to
as
another
saying that
person.
he was 8
You told it
inches
to another
from the
person.
grass,
You
correct?
told it to
About-
another person.
As George was
So far,
explaining it,
I have not
this
heard.
upper half of him, somewhere of this where it was still on the concrete, where the rest of his
Any other-
body was on the grass.
How is this not?
And I think your quote is, I noticed that I'm about 8 inches away from the grass,
Officer?
correct?
Correct.
But he's George's best friend.
And then does
Don't
Mr.
got the
Zimmerman
influence.
defendant tell you that I try to maneuver the body just enough to get my head onto the grass?
It was a squirm, he said. He said as he was squirming
Foreman?
down towards the
Slid
grass to
down?
keep his head from getting hit by the concrete, he says his jacket kind of remained still as you squirm. His jacket, since it wasn't buttoned, it stayed where it was, and his body moved towards the grass a little bit more.
What else did he say about anybody seeing this or coming out?
He said there were several people that came out, at least 2 that he saw that came out, and
Aren't
he
we
directly
fucking getting anywhere?
screamed for help
Charlie
towards
Brown.
those people. So as he
This
was
is
screaming, it was
fucking
more
wasting
directed
time.
at someone.
And did he say one of the
We've heard
individuals
that
that came
already.
out was a man and
Yep.
he
John
yelled
Good.
directly at him and the man just went right back in?
He stated he was going to call 911 and he wasn't going to get involved.
Yep.
And did he say then there was other individuals that
Grumpy
saw
old
this
John
too,
Good.
correct?
Said that.
Perhaps at least one other for sure that witnessed what was happening. It may have been the same person that had the flashlight
Right.
that showed up later.
I think you, and you can refer, if you need to refresh your memory on page 28 where you quoted Mr. Zimmerman. Did you not, at the very bottom of page 28 of your book?
There were several people.
I think you said 2 other men saw us out there and did nothing,
Correct.
correct?
I believe so. At least one other, maybe 2 others.
And then he claimed that Mr. Martin, or Trayvon Martin, was still on top of him and took his hands and put it over his nose, correct?
One hand was trying to cover his nose, one hand was trying to cover his mouth to keep him from screaming.
Right. And I think you quoted Mr. Zimmerman as saying that Trayvon Martin put his hand, takes one of his hands and puts it over my nose and pinches it closed while his other hand goes over my mouth.
It was described to me something like this, maybe pinched, maybe not like that, but pinched like that in the cover.
So in other words, Trayvon Martin is using one hand over his nose and then one hand over his mouth, correct?
Who's
Something
not
to
going to
that
believe
effect.
this man? He seems like a God-fearing man.
And then what does Mr. Zimmerman, the defendant, say happened then?
He said that because his jacket rode up a bit, that perhaps with the inside of his leg he felt or looked down and saw that he had a holster and firearm.
Okay. Before the defendant said that, did he say that he desperately got both of my hands around the guy's one wrist and took his hand off my mouth long enough for me to shout again for help?
Right. That was the main thing he did with his hands, was to try to clear his mouth. Because with his mouth free, he could scream and he could breathe.
Okay. So the defendant is describing to you that Trayvon Martin's got one hand pinching or with his nose, and then he's got the other hand over his mouth, right?
Trying
he can't breathe or
Correct.
I got that right?
Correct.
And then the defendant is claiming that he took his hands and removed at least one hand off of Trayvon Martin.
Off of his own mouth.
Okay. Defendant's claiming that he never hit Trayvon Martin at that time or never just knocked him off of him, right?
That was not described to me.
Okay. And then the defendant told you he had a brief control of the wrist, but then he said, I knew when he felt the sidearm at my wrist with his leg, correct?
Say that one more time, sir?
For a brief moment, I had control of the wrist, but I knew when he felt the sidearm at my wrist with his leg.
That's when he let go of the other hand let go, and he said that he went for the gun.
Okay. Did he
Grabbed
say
for it.
Trayvon Martin went for the gun, correct?
Grabbed for the gun.
Okay. And I think you quoted him as saying he took his hand that was covering my nose and went for the gun, saying something at that point, correct?
He did.
He said, what words did he utter?
He says, "You're gonna die," and he used the MF term again. I'm sorry, I don't like to curse in front of ladies.
And for the record, he used the word, "You're gonna die now, motherfucker," correct?
That is correct.
Charlie Brown doesn't give
And
a
then,
fuck.
I think you got the defendant quoted as saying, somehow I broke his grip on the gun when the guy grabbed it between the rear sight and the hammer, correct?
Could have been the leather, could have been the gun.
Well, I think you quoted him on page 29, and refresh your memory if you need to,
Correct.
as under quotations, somehow I broke his grip on the gun when the guy grabbed it between the rear sight and the hammer. So
That's where the leather strap is, though. That's what holds the gun in.
So the defendant is claiming that the victim actually grabbed the gun,
That was my understanding, that he grabbed the gun. That would have been the only place that was available to grab.
Okay, well, that's
and
different.
then he said the defendant managed to
But
get the
that's
gun in his hand and raised it towards Trayvon Martin's chest and pulled the trigger, correct?
Unfortunately, yes.
And then he claims after he shot Trayvon Martin, that Trayvon Martin sat up and he heard him say, "You got it, okay, you got it," something like that.
Correct.
And then the Trayvon Martin pivoted 90 degrees and fell face forward onto the grass, and he scooted from under him.
Correct.
And the defendant claims he didn't know he shot him.
He didn't know he struck him, correct.
I'm sorry, struck him.
Correct.
In fact, the defendant went on to tell you that he thought Trayvon Martin, I know he wasn't calling him Trayvon Martin.
I understand.
I think he referred to him as the guy or whatever. Might try to get up again, so after putting his gun back in the holster, he jumped on top of Trayvon Martin and pinned him down, correct?
Correct.
And then he said a man approached him out of the darkness and
First
thought it was
man
the
was
police,
not.
correct?
First man was not a police officer. The second was.
And you recall also that when he's describing in terms of the first contact he had out there when he was calling the non-emergency number, that he said, we need you to get to a place where you can see him in terms of observing Trayvon Martin?
Right. Well, that's he had said that he had to get somewhere where he could observe Trayvon or observe any subject that's in his neighborhood to be able to direct police officers to them. So whether he actually whether the dispatch actually said, we need you to move to where you can see them. I'm not sure if that actually was what occurred, but he had said that his instructions from Sanford Police, whenever they came to their complex, was always to get to where you can observe and try not to make contact.
So he didn't really want to make contact. He wanted to observe.
He told you that the officer was almost there at the scene about 45 seconds or something, or the dispatch was telling him that, correct?
I guess time is relative at that point, but yes, very, very shortly after.
I'm saying when he's talking, he's saying the dispatcher's telling him the officer's almost there. He's
Correct.
within 45 seconds.
Correct.
And he told you that, and I'm going back now in terms of when the dispatcher, he tells you that he told the dispatcher just have the officer meet me at the clubhouse, correct?
That is correct.
And that he put his phone in his pocket to turn around to head back to the car when the guy is there about 15 feet away from walking towards him, right?
Correct.
So he's saying that Trayvon Martin, I apologize, I'm using the name Trayvon Martin, but you know who I'm talking about.
Correct.
He's describing this person's 15 feet away and walking towards him, correct?
Correct.
And he says, do you have a problem? And then what occurs? You said he said some other words, MF, but you didn't put it in the book, correct?
Correct.
We've already been through it. Why do you have to interrogate this
He also
man?
told you that when he managed to get his hand off of Trayvon Martin's hands off his mouth, that he had control of the wrist, correct?
To some degree, to prevent him from putting it back over his mouth, yes.
Right. And he told you that the defendant managed to break the grip on the gun where the guy grabbed it between the rear side and the hammer, correct?
Whether it was the gun or the leather casing or just reaching down there and grabbing something.
Right, but I think,
Broke the grip of the gun or the holster.
now, you didn't refer to the holster when you wrote it down in the book, correct? You just put gun.
Correct.
Right.
Because
Okay.
the holsters, that's exactly the place where the holster holds the firearm in place. So whether it was actual firearm or holster, I didn't see a difference. If someone grabs a hold of the holster or grabs a hold of the gun, their intent is probably the same.
And the defendant's telling you then that he shot at Trayvon Martin, but he didn't know whether he struck him or not. He thought
Correct.
the shot went wide, correct?
He did say that.
Let me have a moment, Your Honor. I don't have any further questions.
Thank you, Cross.
Yes, thank you. Morning, sir. How are you?
Fine, sir.
How long have you been in law enforcement?
Since 1992,
Pretty much a
Damn.
career for you?
it is.
And do you enjoy doing what you do?
Very much.
Did you get any college training or anything before going to the police academy?
Well, not before the police academy. I had, right out of high school, I went into the Army. I was in the U.S. Army Infantry. And when I got out, I then applied directly to the Daytona Beach Community College Police Academy.
Completed that and then been in law enforcement ever since?
Correct.
And you've discussed your career with George Zimmerman, have you not?
In detail.
And it was actually you who assisted him when he decided that he needed a firearm, correct?
That is correct.
And did he tell you the reason why he wanted to get a firearm?
He asked whether he should or shouldn't to start with.
Okay.
And I recommended that he should, that anybody who's a non-convicted felon should carry a firearm.
That's your sort of life philosophy?
That's my opinion, correct.
Being armed is better than not being armed?
The police aren't always there.
And
Fair.
you then encouraged him to do that?
I told him if he wished to go and go to a place that actually trains for the concealed weapons permit and to get that training.
Which you know that he did, right?
He did do.
And that he actually got his concealed weapons permit.
I believe him and his wife.
And then they need to decide what weapon that they should, or he should purchase, correct?
That is correct.
And did he seek your counsel in that regard?
He did.
And
Objectives to beyond scope of direction.
Sustained.
let's focus then a bit more. How long did you know George?
About 5 years, or at that time, it was a little over about 4 years at that time.
Okay. And I think you said he's your best friend?
Best friend I've ever had.
Would that affect in any way
Nice.
your testimony here today, that he's a good friend of yours?
Well, not as far as the truth is.
Okay. So you're going to speak the truth, good or bad, for Mr. Zimmerman?
Correct.
And as part of that friendship, you were contacted on the night that this event happened?
I was.
Okay. And offered your help when, and I guess helped Shelley, who was going through what she was going through, right?
Near hysterical. She had called me she was visiting her father's home at the time when she received a call from a neighbor from Twin Lakes. And then she immediately called me. And both of us got into our vehicle and arrived at Twin Lakes about within 10 seconds of each other.
And how upset was she?
Indescribably hysterical. She had almost no information to go on because the neighbor, I guess, that called, they had to hang up. So she couldn't get further updates as to George's health or status or what he had. She was, I put my arm around her just to kind of keep her from blacking out, I guess.
Because at that point, she had gotten a phone call from somebody who actually said that George was involved in a shooting, correct?
She told me that she got a call that said George was involved in a shooting, in handcuffs and bloody.
So you arrive at the area, the complex where it happened, meet with Shelley.
Correct.
Did you see George at that point?
We walked up to where the yellow crime scene tape was that was surrounding. It was a massive area that they had circled off. So we couldn't get very close to the actual scene itself. But inside the crime scene tape was a Stanford police officer car. In the back seat of the police officer car, Shelley and I saw someone who she more quickly identified as probably being George, lean his head down and lay down from the back seat. And he supposedly he had laid straight down to where no one could see him.
And did you have any contact with him at that point?
None. Couldn't get anywhere close.
Okay. Then at some point you went to Sanford Police Department, correct?
Correct. I drove Shelley over to the Sanford Police Department and we waited in their lobby until he was released.
Do you recall about how many hours you were there?
Goodness. 2 or 3 a.m., could have been even longer.
What was his state of mind when you finally saw him at 2 or 3 o'clock in the morning?
Stunned. He immediately attempted to reassure Shelley, who broke down again once she saw him. Once they got out of the elevator, she went into hysterics, kind of a breakdown, maybe not hysterics, but went into a sobbing breakdown. And he immediately tried to reassure her he was okay. And so he was more occupied with her than with anything else, but he had a stunned look on his face.
And when you say stunned, tell me.
Wide-eyed, just kind of a little bit detached, perhaps from maybe not realizing he had just gone through a traumatic event. Kind of odd to describe, very, very difficult to describe.
Let's talk about, obviously, as a good friend for him for the 5 years prior, or 4 years prior, you've known him, correct?
Oh, yes.
And then tell the jury, if you would, how he was that night compared to the George Zimmerman you knew most other days.
That's what I was using to base my observation on, was a more wide-eyed stare. Again, once he saw Shelley, he focused more on making sure she was reassured and that letting her know that he's okay, he doesn't have anything fatal or anything going on with him. He's all right. And she immediately started to observe, once she got out of her shock at seeing George, she then started kind of looking at his injuries, and I guess she kind of went into nurse mode at that point because she was a nursing student.
And again, how is George presenting himself to you?
Detached. It's hard to describe.
Well, is detached different from the way he normally is?
Oh, vastly.
So when you say detached, what do you mean?
I would say probably when you feel like it's hard to describe, sir. I would say he was probably in a position where he was not able to process. His mind wasn't, he wasn't answering questions, because I started asking him some questions about whether he needed to sit down for a little bit, right there in the lobby, and he didn't. He just, no, I just want to go. I just want to go home, kind of thing. And it was very basic. I don't know how to really describe detached, as in wide-eyed and really not processing what was going on.
Did he seem to you to be non-emotional about what was going on?
Coming right off of the elevator, well, he was tending to Shelley and her sobbing, her crying. So he was focused with that. When that went down, when Shelley actually transformed from a wife concerned for her husband to being a nurse, that's when he kind of just had a blank stare.
It was probably.
And then at some point you guys got in the car, correct?
Went to my vehicle, correct?
And then let's talk about
at
the
that
conversations that he did have with you. So
Could you imagine?
give us the setting, if you would, as to how this conversation that at some point in the
I
future you
couldn't
relayed
imagine.
Okay.
as far as your direct examination. So sort of give us the setting
I'm
for
still
what
here.
happened.
I'll be right back.
We get into my vehicle, both Shelley and George got into the back seat. I had a 4-door vehicle. They both got in the back seat, and Shelley is trying to put an assessment on the injuries that were to George's nose, the back of his head, and he had a swelling on his left side of his head. It was about the size of your fist. It was a swollen area, not really a goose egg, not as pronounced as that, but it was a very big swollen area. I'm sorry. And with his head being, his hair being closely cropped like mine, you could see it very well. I guess if he had a lot more hair, he would not have been able to see it as well. But she started tending to that, stating that we needed to get ice on it and such. And when we got stating that she needed to get ice on that part of the swelling, and on the drive from the Sanford Police Department to my home, he explained from start to finish. It took about the whole time that we went from the Sanford Police Department to my home. He explained what had happened that night, because that was the first time we had known any details of anything.
Now, as he was explaining it to you, was this sort of as a friend recounting to a friend, or were you acting in law enforcement mode or as friend mode?
Well, my wife will tell you it's hard for me to get out of law enforcement mode sometimes, but I like to analyze everything I hear to make sure that it makes sense. But I would say part of his friend also.
Okay, so let's start off then, not to belabor too much with keeping in mind your direct testimony, but let's start with, he first told you he was on his way to Super Target?
Correct.
Does that seem usual or unusual to you?
Every single Sunday like clockwork.
And tell me what he said to you about him first noticing, who later became known to all of us as Trayvon Martin.
He observed Trayvon walking between two sets of townhomes and looking into, I believe there was a window to one where the light was on, and you could see that someone was looking into the window of a townhome. And it was about that time that Trayvon and George made eye contact with each other, and both aware of the other's presence.
Okay. And in that initial contact, did he seem to you as though he was angry or anything like that with who this person was?
No. George said that he wanted to make sure that he just got with non-emergency dispatch and had them send a police officer.
And he told you he did that?
Immediately.
And of course, you know from your conversation with George that that entire conversation was recorded, correct?
Yes, I do.
And from your conversations with George, both about this night and other nights, George Zimmerman certainly knows that those phone calls are recorded, correct?
Yes.
So tell me then, again, he's explained to you that Trayvon Martin is now walking up and sort of near his vehicle at some point?
Correct. Came walking from between the townhomes down to where the sidewalk or the road area was.
And are you taking any notes at this point, or are you just listening to him download?
I'm driving.
Okay. So at some point, it became apparent to you that Mr. Zimmerman had stopped his car by the clubhouse, correct?
Yes, he did.
And that Trayvon Martin then came up towards his car, either looked in a window or walked partially around it?
Very close, walked around it, very close. They made eye contact several more times, very aware of each other's presence.
During this point, this sort of second eye contact, did George Zimmerman relate to you in any way that he was angry or anything about Trayvon Martin or this person who was there?
No, not at all.
And he further told you that he was still on the phone, of course, with non-emergency, right?
He remained on, correct.
So then we move forward to, I think you said that George Zimmerman did what he thought he should to keep Trayvon Martin in sight?
Correct.
Is that pretty much the way? Tell me how he related that part to you, as best you can recall.
Well, he said that he had heard from the Sanford police officers that showed up to the clubhouse to give instruction to neighborhood watch people was to always try to keep whatever subject that you're observing in sight. It makes it much easier for a law enforcement officer to show up and make contact. You're on the phone with dispatch during the whole process, and you can actually see the subject.
Did he relate to you that the non-emergency dispatcher had actually told him on a couple of occasions, tell me what he's doing now, or let me know if he's doing anything else?
He told me what he was doing. He didn't tell me that the dispatcher had said certain things.
Okay. So basically, George Zimmerman, as he's telling you the stories, recounting to you actions, correct?
Yes. Oh, yes.
Not necessarily, I did this because of this reason, or I did this, and sort of superimposing the conversation he's having with the non-emergency onto your conversation.
No, not at that time, no.
Okay. He was just saying basically a rendition of what was going on.
Correct.
And just so the jury is clear, about how long was this conversation between George Zimmerman and you during this car ride?
The drive from the Sanford Police Department to near the intersection of Reinhardt Road and Lake Mary Boulevard, which would have been about 14 minutes, 15 minutes.
And during that time, were other things being discussed as well, like whatever Shelley was doing with him?
She didn't interject at all.
Okay. So during this conversation then, he's telling you that he's trying to keep an eye on Trayvon Martin however he can.
That was his intent,
Okay.
was to keep him under observation.
And at some point, well, tell me then, at some point, did he say to you that I couldn't see him any longer, or that he lost sight of him?
That's one of the reasons why he got out of the vehicle.
And tell me how he related that to you?
He said he went in between the sets of townhomes down a dog path, a walking path.
When you say he, you mean Trayvon Martin?
What? Right. He lost contact in the darkness in between the townhomes down that walking path, and then he got out of his vehicle it may have been at the time when someone was asking him, where's your exact location, because the officer was getting close. So as the police officer gets closer and closer to the actual scene, the dispatch likes to tell them exact street numbers, so you can find your place exactly.
Okay.
So that's what he was looking for.
George Zimmerman never told you during the entire of this conversation that George Zimmerman ever went down the dog path, correct?
He did. He left his vehicle and he
Walked down the path.
Walked down the path, correct.
Do you know this area that we're talking about?
I do.
Okay. There's a path that goes straight through to Retreat View Circle,
Correct.
and then a right turn that goes off to the
T.
right. A
Correct.
T.
Yes.
And he had said to you that Trayvon Martin went down the T, correct?
Perhaps, yes. See, that's what he
Well-
believes because the street beyond was lit better than the dog path was. So if Trayvon had gone all the way to Retreat View Circle, he would have seen him or his shadow, perhaps. Because he lost sight of him around the time where the T was, he said, I believe he made his turn down that dark dog path area that was not very well lit at all.
And tell us the path, if you recall, that George Zimmerman told you he took as he was on the phone.
He said he went straight to go through since he lost contact. He wanted to go straight through to get a house number of one of the straight through, not take the right to go down on the T, just to go straight through and find some kind of a house number, because you want to make sure you get the exact house number, because there was a lot of units there on Retreat View Circle. The exact house number would have brought the police officer faster. I believe that's what his intent was.
We've heard
And
that.
he told you he was on his way back when the altercation began, correct?
Correct.
And that they said whatever they said to each other that you testified to.
Still good for the defense.
Just to fast forward, I think you said
The
that
story's great.
you weren't taking
All the
notes
people-
during that event, correct?
I was driving, correct.
Have you ever talked to George again about the facts of this case, or was that the only time?
One other time, I heard him relay the incident
And when was that?
the next morning.
Okay, and we'll talk about that in a moment.
Okay.
During the event in the car, when he said things like, do you have a problem? You do now, or no, I don't. Are those, as best you can recall, the words that George told you he remembered from the night before?
That is correct.
And talking about the actual mounting, when he said that Trayvon Martin had mounted him, I think he said that at one point he was straddling and the knees may have been up as high as the armpits. Is that correct?
Could have been. The ribs area could have been as high as the armpits.
Well, no, I'm just asking
Yes.
you, because what I would like to do is have you tell the jury, without presuming or suggesting ribs, armpits, hips, knees, whatever it might be, for right now, just recount, as best you recall, what George remembered of the event and what he told you.
Well, I guess during the struggle, I guess the position of his knees and legs would probably change with George squirming. So at one point, I believe they were around his ribs with George trying to squirm off of the sidewalk and onto the grass. I guess his knees came up a little higher, and that's very possible. Or the other way around, to where it was as he's squirming, once they get closer to the grass, in a fight, I guess, or in a scrap like that, it began at least here with the ribs, with the knees or somewhere in the ribs area.
Was he consistent, however, that it was Trayvon Martin who had mounted on top of him?
If it was Trayvon
Was it?
that did
Yes.
it? Oh, absolutely.
And was he consistent that it was he, meaning George Zimmerman, who was screaming for help?
Without question.
And he did tell you at some point that there was some hand over the nose, hand over the mouth event.
Correct. But it was raining and it was slippery, I'm sure.
Did he tell you how long that portion of the overall altercation lasted?
20 seconds, maybe 15, 20, 30 seconds.
Some
He didn't mention it.
Well, again, I don't want you to
No, he didn't mention
assume.
it. He did not say how long.
Okay. Did that, however, as he related it to you, seem to be significant as it was occurring to him, that he couldn't breathe for whatever length of time?
It was critical.
And that somebody had a hand, Trayvon Martin, on the nose that had already suffered the previous injury?
Correct.
And as he was relating that to you, was that sort of a real focus of his?
That was the focus. That when he was losing oxygen, he felt he was not able to breathe, and that's why he was desperate to either clear an airway.
And in your experience as law enforcement, would you agree that that's sort of a natural reaction to traumatic events?
I would think so, every time I've seen it.
And do people involved in traumatic events like that sometimes focus on particular parts of it?
Almost exclusively to the omission of others.
For example, in a car accident, you might focus on the speed of the car coming at you and completely forget about other cars around you.
Correct.
Is that unnatural in your experience as law enforcement?
No, it's typical.
So when you go to a scene of an accident or shooting or just anything that you investigate, do you find in your experience that people often have sort of tunnel vision views of what happened to them?
Sometimes very specific, correct?
Does that mean that they're lying to you when they do that?
Not at all.
Why not?
It's been proven that that is typical. Sometimes they'll focus in on one event to the exclusion of others.
How about their ability to just recount events with any particularity at all?
I'm going to object this beyond the scope of direct. I haven't objected.
And then you testified concerning this whole event around the gun. Did you have a similar concern as to Mrs. Zimmerman's ability to recount those events to you?
No.
Okay. Tell me what he did say about having to grab his gun.
He said that Trayvon had reached down and grabbed for the gun, whether it was on the leather holster or on the actual metal part itself. At the time, I didn't see a difference. I just thought that the intent was clear, and that's when he freed one of his hands and went and got the gun. He either broke contact or knocked somebody else's hand away, or Trayvon's hand away from him reaching for the gun or grabbing the gun, and then he drew it.
Do you recall if he even told you that Trayvon Martin had touched the gun, or just that he was reaching for it?
I thought he had said he had grabbed the gun. I've only heard the story twice, and whether it was grabbed the gun, grabbed for the gun, perhaps it was just the intent. But I believed he said he grabbed the gun.
So, and then he told you the rest of the story as you related, correct?
Yes, sir.
About Trayvon Martin sort of saying something to him. Did that seem unusual to you, that someone shot could still say something?
Yes. Oh, no, that's very, very common, unless you're shot in, let's say, the windpipe and in the vocal cords, you would be able to talk for maybe 6 to 8 seconds.
Nonetheless, that George Zimmerman said that he had gotten off and actually held his hands out away from his body.
He had gotten off of George, laid down on the grass, and George had jumped on top of him to pin his hands down. And to, again, try to solicit some help from people that are around.
And yet, when he let the hands go, Trayvon Martin may have brought them back under him. Was that the way it was presented to you?
No.
Speculation.
Oh, yeah.
I apologize for withdrawing.
Yeah, no.
Did he even did George Zimmerman even know to talk to you about the fact that Trayvon Martin's hands were found back under his body?
I did not know that fact.
Okay. So he didn't seem to feel any need to explain that away to you, correct?
Correct.
So now let's talk about your recounting this. Well, you said that you heard a story again the next day.
Next morning.
Any differences in what we've talked about so far?
None.
Okay. And who was that discussed with or in front of?
My wife and his wife, Shelley.
And was it different in any context when it was being discussed then?
George looked different. He was not as wide-eyed, and he did not appear to be as in shock the next morning.
Now, let's fast forward. How many months until you decided to recount this in a book form?
I may have to look. At least 4 months.
Okay. Did you have any conversation with Mr. Zimmerman to corroborate that what you recalled happened, or what you recall him telling you happened was in fact accurate?
We were not able to contact each other after he was arrested the first time. So there was no contact.
All right. And so you haven't talked to him, you haven't shown him, for example, a draft of the book and say, I remember you saying this and him saying, no, that I said this instead.
There was no cooperation with that, no.
Yeah, this is your memory 4 months later when you looked back to that night, correct?
Correct,
And just remember as best you can 4 months later.
correct.
You didn't take any notes that night,
No.
nor in between, did you?
No,
So it wasn't until 4 months later that you went back, sort of scoured your memory to put back together what he had told you on that night, 2 o'clock in the morning on the 27th.
unfortunately, I did not take any notes, so it was just memory.
If you had any facts wrong that were conclusively proven wrong by forensic evidence, would you defer to the evidence rather than your memory of it?
Without question.
If, for
Absolutely.
example, he told you he shot once and there were 4 shots fired, and you had in your book that there was 1, but the forensic evidence supported 4, you would defer to that?
I support that 100%.
And to the extent that he may have told you something, or you remember he told you something differently than it appears in the non-emergency call, which is recorded contemporaneous with the event, you would defer to that?
Absolutely. I may have heard wrong, or I may have documented it wrong.
And even if there was something different that he told law enforcement a few hours earlier in a recorded or videotaped interview from what you recall happening, would you defer to that?
I would.
This is his memory, his recollection. This is hearsay. So again, I don't really understand. I mean, I guess it's hearsay. It's of the party, however that works. I don't
And
know.
at some point during this investigation, you had an opportunity to listen to the screaming on the 911 call, correct?
Me on this government direct. Shut the fuck up, Charlie Brown.
You, as best you could, have testified and have written in your book what the defendant, your best friend, George Zimmerman, told you, correct?
Correct.
You haven't made anything up to help one side or the other, is that correct?
None whatsoever.
And as you stated, the defendant never told you that the victim had his hands underneath his body after he shot him. He said he put his hands out, right?
Correct.
And as you stated, the defendant told you that the victim, Trayvon Martin, grabbed his gun, correct?
Yes.
Okay.
Grabbed for his gun.
Well, I think you've actually,
Grabbed, right. Whether it was, again, where I guess we're going over whether it grabbed the holster part or the gun, I didn't see a difference in the two, but grabbed something.
grabbed the gun. He didn't.
Absolutely. The gun didn't come out, but he
No,
grabbed the gun in the holster.
that's what I'm saying.
Yes, sir.
The defendant didn't tell you, Mr. Zimmerman didn't tell you he grabbed for it. He said he actually got it.
That's what I heard. That's what I thought I heard,
Right,
yes.
okay.
Okay. I'm tired.
Then he told you, I thought I shot wide, but he might get up, so I put my gun in my holster.
Correct.
And he said he put the phone in his pocket, turned around to head back, and the guy was right there about 15 feet walking towards him.
Correct.
Yep.
Thank you, sir.
Thank you.
Thank you.
Very
That's
quick,
it.
one question and response. As to the reholstering of the weapon, do you recall if he told you that it was reholstered as he got up, if he had it in his hand when he was holding Trayvon Martin's hands down, or even at some point shortly thereafter?
He may have had it. He may have had it still in his hand as he jumped on top of Trayvon and perhaps holstered when he saw the flashlight. I don't remember specifically when exactly he holstered his firearm.
Thank you. Nothing further.
You wrote the book that he holstered his firearm.
He holstered his firearm at some point. Exactly when, I'm not 100% sure whether it was
Oh my God,
when he got
it
up
doesn't
from,
matter.
whether he stood up and reholstered, or whether he
Doesn't
holstered while
matter.
still partially on top.
Right, you want to look at your book a minute, if you could, page 29 at the bottom.
Doesn't matter. was his recollection.
Did you quote him as saying, in fact, I thought he might try to get up again, so after putting my gun in my holster, I jumped on top of him and pinned his wrist to the ground?
Correct.
Okay,
What?
was that accurate?
As far as I remember, that he holstered, yeah, at that point, it now remembers that, I remember that it was, he holstered, pinned his hands down. It's what I remembered him saying something like that.
Thank you, sir.
Thank you. May Mr. Osterman be excused?
To remain under our subpoena, Your Honor.
Okay, thank you. You're excused from the courtroom, but you're subject to being recalled. Okay, thank you very much. Ladies and gentlemen, we'll go ahead and take a recess.
Okay. That'd be all for tonight, you wonderful people. That was another fun waste of time. I don't even know what the beginning of this one was. Oh, God. I don't remember. It's been damn near 3 hours. And we had Mr. Zimmerman's best friend on the stand to tell us a bunch of hearsay that George told him. So that was fun. Okay. It is now 2:18 in the morning. Like, subscribe, all of those things right there. Share. Or, do whatever. I'm having fun. Come back. Join me for more. Give me some ideas on what to do next. Okay. Later. Peace. Where's the camera? Thing's backwards. It's backwards. Okay. Later.